Good afternoon, ladies and gentlemen. My name is AlexU-CRCICA, and it is my pleasure to welcome you all to the second annual AlexU-CRCICA Pre-Moot Conference. To begin, we will have a few words of welcome from Dr. Ismail Salim, Director of the Cairo Regional Center for International Commercial Arbitration.
Good morning, ladies and gentlemen, dear participants. The Cairo Regional Center for International Commercial Arbitration is very happy to welcome and host the second annual AlexU-CRCICA Conference, which has followed the second pre-moot to the WILMC, this International Commercial Arbitration moot. We are organizing this conference with a lot of pleasure while taking all the necessary precautions and health measures. And I'm very happy that you are all respecting the physical distancing. I'm not saying social distancing, but physical distancing. I'm also very glad because of the success of the second pre-moot. If we compare the first pre-moot that we have organized together with Alexandria University, last year we had 4 universities participating, 2 from Egypt and 2 from abroad, and the University of Jordan won the pre-moot. This year we have hosted 12 universities participating in this pre-moot, one of which is based in Egypt, which is Alexandria University, the host, the co-host. And we had 11 other universities from the region and even from outside the region. So I believe that this is a great success, and I have to pay tribute to the young professors and the young lawyers and associates and students of Alexandria University for being able to communicate and to create strong ties with notable universities, whether within the region or within the continent, the African continent, or even beyond the Arab world and the African continent. So I was very delighted to see the participation of the University of Nablus from Palestine, the University of Baghdad from Iraq, the University of Lucknow, India, University of Rio de Janeiro, Brazil, and the University of Doha, Qatar, the University of St. Joseph of Beirut, Lebanon, the University of Strathmore University from Kenya, the University of the United Arab Emirates, based in Abu Dhabi, the University of Carthage for the second consecutive year, and the University of Dhaka from Bangladesh. So we see that we have a strong participation from Asia and from Latin America. And finally, the University of Jordan with a remarkable performance and winning the second pre-moot for the second consecutive year, University of Jordan from the Hashemite Kingdom of Jordan. Irrespective of who won the pre-moot and who did not have this chance to win, the general impression was that the participation was the performance of the students who participated in this pre-moot was very satisfactory. And I understand from the arbitrators that it was really difficult to determine who win against the other. So this proves that this exercise is a very useful one and a very efficient tool to prepare the future lawyers to become successful counsel and arbitrators, and by investing in the students, investing in the new generation, this is how we will be able in our countries to promote arbitration. And our countries I would say we are all from the global south. We are all from Africa, Asia, and Latin America. One day, all our countries will practice international arbitration, and we will reach the level that is reached in Europe and in North America. We will be able to match them with your efforts and with your interest in international arbitration. We will be able to reduce the gap between the global south and the global north. I also want to thank the sponsors. The sponsors who are with us for the second consecutive year. They were also with us last year, and they continue to support the pre-moot. First, I would like to thank Shahid Law Firm, our platinum sponsor. I also want to thank Eldib, our gold sponsor. And I would like to thank our bronze sponsor, Matu, Basyouni, and Hennawi Law Firm. And we have had also several strategic partners and our media partner, The Law. We are also thankful to The Law for their effort in supporting this pre-moot. Now, I would like to give the floor to my dear colleague, Professor Mohammed Okesh from Alexandria University.
Thank you, Dr. Ismail. Thank you, Dr. Ismail, for your words and for summarizing the last year. It was actually an idea. We didn't think that it will materialize and we'll have an event. But we had an event last year, as Dr. Ismail said, with 4 teams and a couple of panels. And we were happy to start it. This year, we had 12 teams. And hopefully next year, maybe we'll have more even teams, 24. We're planning for this. I take a great pride for welcoming all the participants, eminent speakers, practitioners, and honorable arbitrators and judges we had in the pre-moot. On behalf of Alexandria University in general, and the Faculty of Law in particular, I want to welcome you in the second Alexandria University CRCICA second international conference and pre-moot. Our aim or goal is to promote arbitration, international commercial arbitration, and to bridge the gap between practice and education. So I'm very happy and delighted to have a group of practitioners and professors coming together to discuss and to share ideas and topics in international commercial arbitrations. And I'm happy for having teams from different countries. The diversity is much more welcomed and enriches this conference and this pre-moot. I want to also thank our sponsors dearly, because without them, we wouldn't have this gathering and conference from last year and this year. So I want to thank Shahid Law Firm for being our platinum sponsor. I also want to thank Eldib Law Firm for being our gold sponsor. And Matu and Hennawi Law Firm for being our bronze sponsor. On behalf of Alexandria University, we really thank you, each one of the attendees, each one of the sponsors, and of course, above all, Dr. Ismail and CRCICA Center for hosting us this year and for supporting us from the beginning. So we really thank you. We hope you will enjoy the panels this day that start after our welcome speech, and we hope to see you again next year. Thank you.
Thank you, Dr. Akesha. And now on to Mohammed Sharif, the director of the AlexU-CRCICA initiative.
Thank you, Malak. Hello, everyone. On behalf of the Alexandria-U-CRCICA Arbitration Initiative, I would like to welcome all of you, whenever and wherever you are, joining us in the second Alexandria-U-CRCICA events. After the success of the first Alexandria-U-CRCICA events, the CRCICA and the Alexandria University decided to continue their partnership and establish the first arbitration initiative in Egypt, Alexandria-U-CRCICA Arbitration Initiative. An initiative that have one main goal, and that is contributing and developing the legal education process through conducting various events and activities for law school students and young practitioners, with a special focus on Africa. Indeed, mooting is the hub that always bridges between academia and real practice. Hence, one of the main events that the initiative will be organizing yearly is the Alexandria-U-CRCICA event. For the past couple of days, we managed to conduct 24 oral hearing practicing sessions efficiently in a semi-remote AlexU-CRCICA VIS pre-moot, providing teams from 12 different countries from Latin America to East Asia with the chance to practice their VIS moot oral arguments before professionals in the field. Now it's the time for the mooties to witness the best in the field, heatedly discuss and argue the very topics concerned in this year VIS moot in the Alexandria-U-CRCICA Conference. In Professor Eric Bergston's words, the VIS moot is not a competition, but it's an educational program. The competition is just what makes the moot. It's just what makes the fun part in the moot. You are all winners. And as for mooting myself, I know this is real. And as Vienna moot starting tomorrow, I hope that you learned from this moot as much as we did. Hope all you will enjoy your time today, and we wish you the best of luck to all the VIS mooties participating tomorrow at the competition. Now I would like to invite my colleague and partner of success, Karim Ruby, to give his welcome words. And once again, thank you for joining us today.
Thank you, Mohammed. Actually, this year, our event is a very special one for us, as it is the first event to be organized by the recently established Alexandria-U-CRCICA Arbitration Initiative. This couldn't have been possible without the support of Alexandria University and the Cairo Regional Center for International Commercial Arbitration. So we would like to thank Alexandria University and the CRCICA for their constant support of the law students' activities. This couldn't have been possible as well without the support of our sponsors, our platinum sponsor, Shahid Law Firm, our gold sponsor, Deep Advocates, and our bronze sponsor, Madubas Uni, for supporting us and sponsoring us for the second consecutive year. So many thanks to Alexandria University and the CRCICA and our sponsors. Many thanks to the attendees of today's conference and the participants of our pre-moot for their outstanding performance. And we are looking forward to meeting all of you next year. Thank you so much.
Thank you to all our speakers for these lovely opening addresses. As you've no doubt gathered, this event aims to further international legal education under the specific angle of the Willem C. VIS International Arbitration Moot. And this year, our speakers and panelists will tackle general issues under the CISG and specific procedural issues raised by the VIS problem. First, we would like to start with a few addresses by our sponsors and event partners. Starting us out is Shahid Law Firm, our platinum sponsor, through its managing partner, Mr. Girgis Abd Shahid. Shahid Law Firm was established in 1987 by Councillor Tharwat Abd Shahid and has grown to become one of the leading international law firms in Egypt and the region. With over 100 lawyers and staff, the firm's practice areas range from capital markets to corporate, to commercial law, to construction, to telecommunications, to energy, to IP, and to dispute resolution, and beyond. As a returning sponsor of the AlexU Pre-Moot, we appreciate the firm's continued support of our efforts and in promoting arbitration among the lawyers of tomorrow. Mr. Gegersat.
Thank you very much. It's actually an honor for us to be accepted to sponsor this event. I'm actually looking forward. I look forward for it every year, and I hope that we continue to be your partners for years and many years to come. Okay, I'll be older, but there are more younger generations. All right. Speaking of old and young, last year we've spoken about that this is our time, and as you have seen. The 40s, the people in their 40s and maybe early 50s are ruling the legal world. I thought of saying, how? What did they do? What did those people we have to look at and look up to did? They had no excuses. They have studied, they have excelled, they have mastered the languages, they have mastered the proficiency of negotiations. They have mastered everything that they have done. And that meant a lot of perseverance, giving themselves no excuses, not saying the internet broke down, not saying my Arabic sucks, which is very new to me. Unfortunately, in this Middle Eastern world, I was coming to say my English sucks, but now I'm hearing more the Arabic sucks, which is terrible. Anyways, the essence is you should not have an excuse for yourself. You should not say, I'm religious. You should not say, the world is against me. You should not say, I'm a woman and the world is not good for women. Actually, women are much stronger than men nowadays in this legal environment. So please do not give yourself any excuse. Nothing is accepted. Once you don't give yourself an excuse, you look up to yourself. You say, I'm the woman. All right?
The era of men is over.
So you have to find your edge. A university degree is no longer it. It's not enough. Frankly, a master's degree is no longer it. You have to find an edge. That edge is either you're awesome at something, you master the languages, you have 4 languages here, you have social skills like crazy, you are one hell of a drafter, you are one hell of a negotiator, you managed to read Sanhuri and upscale it somehow. You know, I have an issue with Sanhuri. And there are multiple edges. We are 6 billion people in the world. I don't know how many lawyers are from these 6 billion, but every one of us has an edge. Find that edge, make use of it, invest in it, use it to your benefit. So now you look up to yourself, you say, I'm the woman. Okay, you have to put yourself down again. Putting yourself down is by humbleness, right? When am I going to be partner? When am I going to be the person of it? No, be humble, take your time, invest in yourself, give yourself every chance to be something. محدش يتكبر على شغلانة. Do it from scratch. Do the indexing. Do the legal research. Do the donkey work. Sorry for the language. Say yes to the partner all the time, even if the partner is like anal like me. Anything, all right? Just say yes. Be humble. Do the work. Finish it. Excel in it. And find your edge. Good luck, guys. Thank you very much.
Thank you, Mr. Abdul Shahid, for that inspiring and enlightening speech. Next up, we have speaking on behalf of our gold sponsor, Ms. Nada El-Dib, the firm's business development manager. Established in 1875, making it one of the oldest law firms in Egypt and the Middle East, El-Dib Advocates is a full-service international law firm based in Egypt, widely respected for the depth of industry knowledge and the firm's strong team of professional attorneys and well-experienced staff. They cater to clients' needs across 20 major practice areas in 4 locations across Egypt. As a returning sponsor of the AlexandriaU-CRCICA Pre-Moot, we would like to thank you for your continued support of the event. Ms. El-Dib.
Good afternoon, everyone. I have to say, everyone kind of said exactly what I was going to say, so I'm going to try and make it as short and brief as possible. Good afternoon, honorable guests, colleagues, ladies and gentlemen, and the young legal minds of the future. My name is Nada El-Dib, and I'm delighted and honored to be speaking to you guys here today at the 2nd annual Alexandria University CRCICA Moot. It's with great pride that our firm, El-Dib Advocates, and members of our team have supported this incredible initiative. I remember speaking to Muhammad while he was interning at the firm about partaking into such a difficult event. And I explained to him how it's going to be strenuous, tactically challenging, and as you all might know in Egypt, a lot of paperwork. But Muhammad, the University of Alexandria, the professors, and all the eager students did not fail. They've not only been able to have one pre-moot last year, but the second one with complete and incredible success. And as Dr. Ismail said, we went from 4 teams to 12 teams, and the global reach is incredible. So you guys have to be very proud of yourselves for actually achieving that. We also have to note that you guys did that through not 1 year of COVID, but 2 years of COVID. And it's this global pandemic, which basically has paralyzed the world on so many different facets, yet you guys keep on championing through. I applaud your dedication and success. And of course, none of this would have been possible without Dr. Ismail Salim and the support of CRCICA and the University of Alexandria and its professors. You guys are promoting such wonderful future legal thinkers in Egypt and across the globe. It has been a few years since I was at university. And when I attended university, many things have changed since then. For one thing's for sure, a conference of this magnitude being held virtually would have been impossible. Possibly, it would not have been feasible to do. And I hope that you guys recognize how technology has come to accommodate this global pandemic. I know, and I'm sure that this crisis has affected some of your education, but think of the generations ahead of you, before you, who probably wouldn't have even had that option. They would have been stuck, not being able to excel whatsoever. And you guys actually took advantage of it and kept moving forward. So, but you guys always do. You take the extra mile and you've never settled. And I've seen this with a lot of you guys because we've had the privilege of having you intern with us. You've taken the challenge. You're building a foundation for your career and for your futures. And I can confidently say that you all have an appetite to excel, which is something that will definitely be ingrained in you and will continue fostering your better future. It's wonderful to be part of this initiative, and I would like to thank the university and the center, but for being able to actually handle this both virtually and in person. It is it's a daunting task, and I applaud you for doing this greatly. One of the main ethos of our firm is to strengthen the community around us, and we believe in educating the up-and-coming legal thinkers of the next generation. It's key both for our society and for the future of the law. Our internship program has expanded over the last few years, and we've run our internship program mainly out of our headquarters office in Alexandria, and I'm happy to say I see a lot of familiar faces. And we're hoping to continue expanding this across all our offices in Egypt to give everyone this opportunity. One of the main things also our firm values is commitment to trusted partnership. And when we talk about partnership, we don't just talk about our partnerships with institutions, universities, but our partnership with you guys, the students, the future. You guys are ambitious you guys are driven and you will move up the ranks into the roles of the people who sat in the tribunals in the past few days questioning your arguments. As the famous saying goes, the students will become the teachers. One other thing that I always like to stress is that we believe in shared success. And I'm proud to say over the years that we've equally trained men and women at our firm, right? Am I right? Okay. We've equally trained men and women, and hopefully over the years we'll continue to do this. We value success of our team, and we recognize that our trainee success is in part the success of our firm. And we will continue to dedicate our team's work and our cooperation in order to work hard and support your future successes. We thank CRCICA wholeheartedly for being a generous host and having us here on your premises and using all your facilities over the last few days. However, we have to give a shout out to our hometown, Alexandria. And we really do hope, Alexandria, thank you. At the University of Alexandria. And we really do hope that we can sway you guys back to Alexandria like last year and host it there in person, fingers crossed. And what better venue than for us to do it at the Alexandria Biblioteca Alexandrina. It's with its history, its museum that has a bit of information about Alexandria and Egypt, over 1,300 manuscripts, and I'm sure within there, 8 million books and 1,300 artifacts and manuscripts. This is something that is remarkable not only for the city, for our country, and for you guys who, as you said, read, do your homework, excel, find your edge. So hopefully this will help you find your edge if you want to work a little harder. So with that being said, I applaud you guys all. I applaud your efforts. I applaud your success, and know that this is the start of great achievements, a lot of challenges, but great accomplishments. Thank you very much.
Thank you, Ms. Nada Deep, for those warm words. I'm sure we'll all remember them. Finally, speaking on behalf of our media partner, the law, is Mr. Ziad Ali. The law's activities include publishing Egypt's first national glossy professional magazine in the legal field, exclusively for the Egyptian legal profession, the Law Magazine, which provides an opportunity for professionals, graduates, and students to contribute together in the legal field. It also organizes an annual conference, aptly dubbed the Law Talks, which promotes networking between professionals, students, and graduates. The organizers would like to extend their thanks to the law for their involvement in the events both this year and last year. Mr. Ziad Ali.
Hello. So, ladies and gentlemen, we are delighted to be invited to the AlexandriaU-CRCICA Moot. These kind of activities are the foundation of our legal industry. It empowers our students. It keeps our profession moving forward. Moot courts do make the best kind of lawyers. Empowering young generation make good lawyers. Therefore, let's take a round of applause for everyone who invested money, effort, and most important, time to make this event happen and to make it come to life. Thank you all for this. It's an honor and duty to take part of development of the justice system for a brighter generation. And finally, I would like to invite you all for our next award magazine and our coming webinars to connect the legal industry together for being stronger than ever. And thank you all, and best of luck for all the parties in this process. Thank you.
Thank you, Mr. Ziad Ali. Keeping it very short, very sweet. Thank you. Our first session will be on the introduction to the CISG, the alien creature in Egyptian legal jurisprudence. Our speaker is Mr. Sharif Al-Saadani. Mr. Sharif Al-Saadani is a partner at Umbrella in Cairo. He specializes in dispute settlement with a focus on international commercial arbitration. He is a former scholar of the UNIDROIT and the Institute for Comparative Law, Conflict of Laws, and International Business Law at Heidelberg University. Throughout his almost 20-year career, Mr. Saadani has advised clients on corporate and commercial practices, as well as dispute settlement in various fields, including international sale of goods, which providing him with practical insight into this session's topic. Seems that he is a bit late though, so.
Since we would like to abide really by the time allocated to each session, because we really want to stick to our timeline. So we will inquire whether Mr. Sharif Al-Saadani is about to arrive or not. If there is an issue with him, I would like to know if Professor Amal Abdullah is.
You can reach her. She's limited on virtual.
Okay, is she ready or? Anyway, Mr. Sharif Al-Saadani's speech is supposed to start at 2:30. So now, yes, 5 minutes from now, more or less. So we can still wait and see whether Mr. Sharif Al-Saadani will be able to arrive on time, or we can see with Professor Amal. If you can also communicate with Professor Amal. طبعا بايخه جدا. So I would like everyone to stay in the room unless there is really a necessity, but because we really want to respect the timeline. You are allowed for 5 minutes only as a break.
If you could all please take your places, we'll get back to our conference. So again, this next session is the introduction to the CISG, the alien creature in the Egyptian legal jurisprudence, given by Mr. Sharif Al-Saadani. Mr. Sharif Al-Saadani is a partner at Umbrella in Cairo. He specializes in dispute settlement with a focus on international commercial arbitration. He's a former scholar of the UNIDROIT and the Institute for Comparative Law, Commercial Conflict of Laws and International Business Law at Heidelberg University. Throughout his almost 20-year career, Mr. Saadani has advised clients on corporate and commercial matters, as well as dispute settlement in various fields, including international sale of goods, providing him with practical insight into this session's topic. Mr. Sharif Al-Saadani.
Thank you, Mark. First of all, I'm humbled and honored to be presenting to you today in front of eminent scholars and people that I usually reference in my submissions and writings. But it's not new to CRCICA. It hosted the first CISG conference in Egypt back in 2005. Dr. Mohammed Abu Al-Ainain hosted Professor Schlechtrim, Schwenzer, and many eminent scholars in the field, members of the drafting committee actually of in the Vienna conference. Again, Alexandria University hosted a conference later on, 3 years later, and hosted Mr. Kritza, as always a referenced scholar in the field of CISG. So let's back up a little bit and discuss why the CISG is so important as a convention. Why are 380 universities competing worldwide in Vienna every year for proving scholarship and understanding of CISG? Why is it celebrated as the most successful project of uniform law? That is, of course, substantive, procedural. The New York Convention for the Enforcement of Arbitral Awards stands out. Why is the UNCITRAL clout, the case law database, dominated by thousands of decisions worldwide on arbitral awards that apply CISG? But here comes my question. Why are only 5 Arab countries signatories to the convention, parties to the convention? Bahrain, Egypt, Syria, Iraq, and Mauritania. Why is our Court of Cassation the most prominent trendsetter, legal trendsetter in the Arab world? Why did it only issue 2 decisions so far? One in 2006 and one just in July 2020. Why isn't there any case reporting to the PACE University database or the clout at all from any university in the Arab world? So, and I find this question very remarkable and very it's due to ask, because Egypt was one of the first 10 countries to accede to the convention. Dr. Mohsen Shafi was one of the members of the drafting committee. A handful of people attended the Vienna conference in 1980, and Mohsen Shafi was one of them, Professor Mohsen Shafi. And until this very day, his book that was published in 1980 is still the most referenced and the only reliable source of information when it comes to the CISG. So I am putting this question up for debate. And I have another question, which is, so we acceded to the convention in 1982, but it was published in the official gazette in 1997. So we're talking a gap of almost 15 years between the accession and the ratification. And so many people ask this question, and the question can be easily answered. It remained in a drawer of an employee of the Ministry of Foreign Affairs for 15 years in a unique accident, unprecedented and very, very, very weird incident, to be honest. And it hasn't been before and was never repeated afterwards. But this is what happened 15 years. This is why we have ratified the convention 15 years after acceding to it. And it should be applied retroactively since 1988, which is when the convention came into force. So my presentation will be divided as an intro, which happened now, and then a brief description of the skeleton of the convention. And then I picked two topics or two rules that have changed in the commercial code, in the Egyptian commercial code, and were directly affected by the convention. It was affected on so many levels and in so many ways, but these are I have only less than 17 minutes, so I'll try to be brief as possible. So why is the convention important? It's important because the uniformity in the CISG is unique. So its predecessors. It's not the first project to try to make or produce uniform rules on international sales. It was preceded by the Uniform Law on International Sale of Goods and the Uniform Law on the formation of contract for international sale of goods. Both were signed in 1964. Only 9 members. And it was very criticized for being biased and not inclusive of developing countries. So it was much exclusive to developed countries. And this is why it didn't have that much popularity. The CISG is a true compromise between the two main legal systems, the common law and the civil law. That's why we have in the US now courts applying good faith, the principle of good faith, and we have and courts in France applying estoppel, and that's long before our Court of Cassation generalized the application of estoppel in November 2020 across all contracts and not only restricted to arbitration. And Mr. Nabil Abran would definitely be more informative on this subject, and I'm honored to speak in a conference that he would be a speaker in. In this regard, the uniformity, in this regard, Article 7 is very explicit and it addresses courts directly. It states that regards should be made to its international character, the need to promote uniformity and its application, and in its application and the observance of good faith in international trade. So the courts are requested not requested, mandated by the convention to disregard its local rules, its domestic rules on interpretation, and pay regard to its international character and the need to promote the uniformity, which basically is translated to making analogies to other provisions in the convention if there are no explicit rules governing the dispute that it's reviewing. So, for example, if we look at Article 13 of the convention, it states that it defines the writing to include telegram and telefax. So it does not include emails. So courts have easily applied Article 7 and made emails and other means of communication between parties within the scope of the CISG. So the courts are again in parties to the convention mandated to follow court precedents worldwide and see how they apply the convention and disregard its domestic rules and resort only after resort to the general principles, and the analogies made to the general principles are exhausted. So this is a unique feature of the CISG that courts and scholars should be aware of while reviewing cases. So the CISG had a tremendous effect on domestic laws. To name a few, the German Civil Code, which is a very established civil code, has been directly affected by the CISG. The OHADA Uniform Act on General Commercial Law, the sales section is entirely based on the CISG. And the Egyptian Commercial Code is no exception, but it's mainly unnoticed. So the travaux préparatoires for the Commercial Code explicitly stated several conventions and mentioned the CISG explicitly. And then Article 88, paragraph 2 of the Commercial Code stated that the UN Convention should be, or the International Convention should apply to international sales, but it didn't explicitly mention the CISG. So I'll come to the skeleton of the CISG. It's basically in 5 sections, in 5 parts. So the first is the sphere of application, which is the scope of application. The second is the formation of the contract. And then we come to the obligations of the parties, and then the final provisions of the convention. So the sphere of application is quite important to understand. The convention gives party autonomy a great value. It allows the parties to derogate from all or part of the provisions of the convention. So the parties may exclude the application of some provisions and include the application of some provisions. It's the convention applies primarily through if two parties are residing in 2 different states parties to the convention, or if the conflict of laws rules would point to the application of the law of a party to the convention, which means that no value is given to the character of the parties. So it's irrelevant if they're merchants or not. It's irrelevant if it's repeated, so it's recurrent. So the only criteria that is used here is the residence of the parties in different countries. It applies to cross-border sales. It doesn't apply to domestic sales. It excludes explicitly types of sales like electricity, like ships, vessels, negotiable instruments, securities, and goods that are meant to be consumed by households, families, and personal use. So these are explicitly types of sales that are excluded by the convention. Otherwise, they would apply. The convention would apply to every sale that is cross-border if the residing parties are in different countries that are parties to the convention. Services. So this is a very important aspect, and I think if the courts are more familiar with the CISG, it would change, I would say, jurisprudence dramatically, because the convention would apply to mixed contracts, so contracts that have a sales aspect to it and services, but the predominant factor would decide whether the convention would apply or not. So you see the predominant element in the contract, whether it's services or sales, and you would determine, the court would determine, or the arbitral tribunal would determine whether the CISG would apply or not. So if we take, for example, public works contracts, if they have a subcontractor that is a supplier and would take on the installation of whatever it supplied, if the value of the goods themselves, the value of the goods itself is higher than the value of the services, and it's dominating the price, then CISG would apply, and this is very much disregarded by many scholars and due to infamiliarity, basically, not because they intend to. The second chapter of part 2 discusses general provisions. So, and the most remarkable principle is or not the principle, the unique feature of the convention is the way courts interpret the convention. It should be so general. So the general principles of the convention are to be to prevail over domestic rules. Like I said, the international character, the need to promote uniformity of application, but the questions not settled by the convention should not be referred to domestic law, should not be referred to rules of on sales in domestic law. They should be referred to the general principles of the convention, and if no analogy is possible, only then domestic rules of the law that is decided by the conflict of laws rules in the court reviewing the dispute would apply. And I put the example of Article 13 that included emails, although explicitly only referring to telegrams and telefax. I chose two rules that have been affected directly by the CISG in the domestic rules of sales in Egypt, in Egyptian Commercial Code, which are, so there are many aspects that have been influenced by the CISG directly, as I said, like the German Civil Code and the OHADA Act on commercial transactions. So I chose two rules that have been affected. These are so regarding the formation of the contract and the obligations of the parties. So with regard to the formation of the contract, the commercial code or Egyptian law for the first time recognized what is known as the open price contract. So the open price contract is basically, regardless of the intention of the parties at the conclusion of the contract, and regardless of whatever they intended when they concluded the contract, the court can set or determine a price. So in the Egyptian Civil Code, as long as it is determinable, the price, the contract is valid. So the contract is validly formed, and basically the court would go to the market price and seek the average now in light of the commercial code, the new rules on sales in the commercial code. The new aspect is that it is irrelevant whether the parties intended to set the price at the time or not. So and the paragraph 2 of Article 89 of the commercial code is very interesting. So in the civil code, it's never been discussed, or it's never been regulated to refer the determination of the price to a third party, but it allowed it. I mean, according to party autonomy rules. But in paragraph 2 of Article 89, the novel thing is not only is a third party explicitly mentioned as a reference to decide on the price of the contract. It's not possible under the civil law rules for the court to take over and decide if that third party failed to determine the price. But now under the commercial code, under the new rule that has been affected directly by the CISG, it is possible. So this is significant. This is very significant, and it's a deviation from a very established rule in civil law. And it distinguishes commercial sales from civil law sales drastically. So it basically removed the prerequisites of the party's intention, and the price is set automatically by reference to the previous practices of the parties. And in its absence, resort should be made to the average price in the market. No mention of an intention of the parties or the meeting of the minds. So the meeting of the minds when it comes to the price, which was a prerequisite to the validity of the formation of the contract, or the validity of the contract, is irrelevant. And this is a direct effect of the CISG in the domestic rules of commercial sales. And I need to say at this point, so there are no rules or provisions on commercial sales in the code that preceded the 1999 code. So that's an aspect that has to be put in consideration. I come to the second point, and I think that should be the last thing I should be talking about, is the self-help solution, the self-help sale solution that has been introduced by the CISG. It's been imported by the commercial code in a very unique, again, deviation from very established rules on termination of contracts and fundamental breach by the parties of the contract. If the buyer delayed the payment or the taking of possession of the goods, reasonable steps are to be taken by the party that holds the possession, holds the possession of the goods, according to Article 85 and then 86, seller and buyer. So the buyer, at some point, if the buyer rejects delivery of the goods, but it did take possession of the goods because the seller was not at the place or the time of delivery present, it has an obligation to preserve the goods, to mitigate the damage. That's a general rule. But the new rule is, that has been imported by the CISG, is that it is allowed to sell the goods if it is feared that it can rapidly deteriorate, or if the preservation of the goods is too costly. So if the expenses are too high for that party that possesses the goods, then it is allowed to sell it. There's a different rule in the commercial code when it comes to buyers if they reject the delivery but still took possession of the goods. It should resort to court. So the court would decide the manner by which the resale of the goods should take place. So it's not only a notice, like when the seller is not paid the price of the goods. It's not only a notice to the buyer. No, it has to go to a court and seek its instructions or decision on how to go about the resale. So I think at this point I'm done with my presentation, and I sincerely thank CRCICA for collaborating with the Alexandria University to handle this very, very popular but somewhat unnoticed in Egypt for some reason. But I think we're gaining interest of scholars at this point, but with the Court of Cassation's decision, I think things should move forward from now on. And thank you for listening.
Thank you to Mr. Sharif Sadani for a very comprehensive talk on the CISG's provisions. Our next speaker is Professor Amal Abdullah, who speaking on the scope of application of the CISG. Professor Amal comes to us via Zoom. She's an associate professor at the College of Law at Sultan Qaboos University in Oman since 2008. She is a practicing arbitrator at the GCC Arbitration Center and has vast experience in Arab laws. Her areas of specialization include comparative law, arbitration and international contracts, among others. A prolific author, her publications include a chapter on the impact of the CISG on the domestic law of electronic transactions in the Arab world. So please, Professor Amal, go ahead. I think you're muted, I believe, right now.
Good afternoon, everybody. I hope you are hearing my voice clearly. Hello?
Yes, we can hear you clearly.
Okay. First of all, I'd like to congratulate everybody participating in this event for this distinguished effort. Now I'm going to show you my presentation about CIG scope of application and the meaning of gray area included in this scope of application. But first of all, I'd like to share my screen with you just to help you to concentrate more with me. I wonder how can I do this? Okay. I wonder if my screen is seen to all of you.
Yes, 1 minute. We are waiting for the screen to be showing. Did you open the PowerPoint?
Yes, it's already open. And according to my computer, it's already shared.
Okay, so it will take some time to be showing.
Right now. It shares?
Yes.
Okay. I'm seeing it now clearly. Okay. Today I'm going to talk to you about the scope of application of CIG from the point of view of the gray area, the point of conflict of the point of weakness of CIG, which opens the door for more conflict at the time of applying CIG on any international sale of goods. Actually, that matter of scope of application is a historical obstacle in any road to uniform rules concerning international sale. Scope of application of CIG considering the more simple 4 letters of this convention, CIG, Contract of International Sale of Goods. It looks very simple and clear, but actually the hidden is more immense. Some factors spotlight on several points of conflict concerning the scope of application of CIG, which we can call gray areas. Actually, the scope of application of CIG or of any type of international sale constitute a historical obstacle to uniform rules in international sale. This obstacle is very traditional. We are going to see it with unidroit and with unicitral. Actually, Convention of International Sale of Goods and its 4 letters of convention may look or may render the scope of application of CIG simple, but as I told you before, hidden is more immense. Why? Because the characteristics of national laws of sale of goods in any state lead to the problematic of scope of application of any uniform rules. The legal tradition of national laws with the fork on the road to uniform rules of international sale of goods since 1930s. Now I'm talking about 5 decades before CIG. We didn't hear about unification of rules of international sale before 1980 or maybe before 1960s. But actually the effort started earlier. Now it's time to remember the Austrian scholar and academic Ernest Rubel. Ernest Rubel started his effort with unidroit to adopt the project of uniform law of international sale of goods in 1926. In 1930, unidroit set up a committee to uniform rules of international sale. For 9 years, several meetings, comments, discussions to draft uniform rules in international sale, but they couldn't reach to the result due to the effect of national legal traditions dominate all of members of this committee. The effort stopped with the Second World War, and they get again in 1951 when the government of Netherlands organized a conference in Hague and appoint a special sales commission with Ernest Rubel as a member to continue their effort to unify rules of international sale. The Sale Commission couldn't reach the unified group of rules concerning international sale of goods, again due to the influence of national legal tradition. Finally, the Commission produced 2 drafts for 2 conventions, ULIS and ULFC, which we call Hague Conventions of 1964. Why we call 1964? Because these conventions has been ratified in a diplomatic conference in 1964. a convention to uniform law on international sale, and a convention on the uniform law on the formation of contract for the international sale of goods. They couldn't reach the unified convention due to the effect of national legal traditions. Actually, both conventions entered into force in 1972, but both of them were unsuccessful due to very limited number of members, mostly European, mostly Western Europe. But in 1966, a new player came to the field, which is UNICITRAL, United Nations Commission on International Trade Law. The first project of UNICITRAL is to form a working group to examine the two unsuccessful conventions, to modify it or to create a new text. And they did. They created a new text, which is CISG in 1974, and it has been adopted in 1980. CISG avoids the main point of weakness of the previous two conventions. They try to avoid the effects or the influence of national legal tradition. They try to reconciling different legal traditions regarding the international sale of goods. Also, CISG entitled the contracting parties to adopt or avoid being subject to the convention totally or partially by giving the choice of opting in or opting out according to Article 6. They opened the door and they enlarged the scope of application of CISG in order to attract more member states for this convention. It's an attempt, but we are wondering if this attempt achieved the target or not. Now we are going to move to talk about CISG as a scope of application to declare what gray area we are talking about. Actually, CISG, it has been adopted in 1980, but it has entered into force in 1988. So now we have 40 years of adoption with 33 years of practice, with 94 parties, 7 of them are Arabs. We have Syria, we have Egypt, Syria, Iraq, Mauritania, Lebanon, Bahrain, and Palestine. About 3 decades of practice and 94 members, the practice put the light on 2 important facts. First, CISG requirement of application contains several matters constitute points of conflict, which constitute a gray area. Also, CISG legal scope of application contains several matters constitute a point of contact, not a point of conflict, but a point of contact between CISG and national laws of state. Is back to the national legal tradition, the entitled courts or arbitrators dominate the application of CISG by their own legal traditions, which create another gray area. Regarding CISG requirement of application, the point of conflict, the main requirement of application contains main points of conflict: internationality, sale, goods. Regarding internationality, according to Article 1 of CISG, the parties to the contract of sale have, if the parties of contract of sale have their place of business in 2 different members, CISG member states, the convention will apply. If not, even if the rules of private international law lead to the application of a law of a contract, national law of a contracting state, also the convention will apply. The convention tried to deal with different matters concerning this place of business, like several places of business. They decided to accept or to consider the closest place to the contract. At the time, any of the parties have several places of business. But who can consider the closest place of business? How to consider the place of business? The closest place of business. Which criteria should be adopted to consider the closest place of business to the contract? All these matters decided according to the discretionary power of court or arbitral tribunal. Now we are getting back to the influence of national legal traditions. This national legal tradition dominates the application of CISG in different countries. For example, in some cases, CISG applied where the requirement of internationality were not met at all. We have a famous decision of Supreme Court of Slovenia, 8 April 1989. It's already published in CIG online sources. There is no criteria to apply CIG. Despite this, the court applied CIG. Another gray area arrived with the modern technology when we started to talk about virtual place of business, when we couldn't consider a certain place of business for the party, for any of the contracting parties, we started to talk about virtual place of business. But recently, concept of cyberspace has been considered by different scholars to determine the requirement of internationality in case of virtual place of business. So this gray area tried to be covered by scholars to avoid getting rid of application of CIG. Regarding internationality, the fact that the parties have their place of business in different places would be disregarded if it wasn't apparent at or before the conclusion of the contract. The burden of proof in such case would be for the shoulders of the party who already would like to apply CIG. National law of evidence will play an important role regarding the matter of burden of proof. And again, we are going to see the influence or the effect of national legal provisions. Also, CIG may apply if the rule of private international law due to the application of law of the contracting state. But in such case, we couldn't guarantee application of CIG unless we are sure that the state didn't use the reservation of Article 95 of CIG. In such case, and if the state uses it, we are going to survive by being subject to the national law of this state and not to CIG, according to Article 95. I'm not going to read it due to the time. I'm going to save the time for more issues. The second requirement to apply CIG is the sales contract. The CIG actually didn't expressly define contract itself, but this definition could be concluded from the rules and the application of the parties, such as Article 31 and 35, where the seller is bound to deliver the goods and where the buyer is bound to pay a price. In such case, we can talk about contract of sale of goods. Certain types of contract of sale is precluded expressly from being subject to the application of CIG, but we still have a problematic concerning this contract. For example, goods to be manufactured or goods containing certain elements as mentioned by my colleague minutes ago. Actually, the practice shows considerable controversy concerning the excluded types of contract. First, goods to be manufactured. According to Article 3.1 of CIG, CIG will apply where the seller is bound to produce the goods in such case, it will be.
Professor Amal, I'm sorry to interrupt you. If you could just bring your microphone closer, as sometimes it goes further and your voice becomes unclear, please. Okay. Thank you very much.
Is it okay now?
Yes, this is very good. Thank you.
Okay. I'm going to repeat. According to goods to be manufactured, Article 31 of CIG will apply, stated that CIG will apply where the seller is bound to produce the goods, as the contract would be deemed as a contract of sale. But if the party who ordered the goods undertakes to supply a substantial part of material necessary for such manufacture, that contract wouldn't be subject to CIG. Here, we have two gray areas. First, what does it mean by material necessary for such manufacturing or production? Second, what does it mean by substantial part? The raw material needed for production usually considered as a substantial part, and mere accessory element will not be considered as a substantial part. But who can decide the substantial part? Again, here we are going to touch the national legal tradition, that the discretionary power of courts or arbitral tribunal play an important role to distinguish between substantial part and accessory part, and it should be decided case by case. For example, we have a decision by German court in Munich consider two elements to specify substantiality: the value and the function of the material provided by the buyer. This German result, let me call it German result, based on a comparison between the French and English text of CISG, substantial part and essential. Substantial refer exclusively to the monetary value of the material, while essential may accommodate different factors: nature of material, particular interest of the parties. Another example concerning the know-how. The provision of providing know-how, plans, design by the buyer counts as a material necessary for the production in the sense of Article 3.1 of CISG. It could be considered a scholar's opinion that it's the opinion of the Advisory Council of CISG. So different scholars or courts or arbitral tribunals sometimes try to state or to color this gray area, but still in sometimes. Sales contract, another part or another gray area in sales contract concerning mixed contract, where the contract contains a service element. CISG in this part use another term where Article 3.2 of CISG states that the CISG doesn't apply to contracts in which the preponderant part of the obligation of the seller consists in the supply of labor or other service. You have to notice that here, drafter of CISG used the term of preponderant part and not the term of essential part or substantial part. If there is one single contract consisting of both the delivery element and the service element, CISG wouldn't apply to such contract if the service element form the preponderant part of the obligation of the seller. So what does it mean by preponderant part? And why the drafter used preponderant part, not substantial part? Regarding the scholar's opinion, this gray area tried to be covered by two teams, more scholar's opinion and court. Regarding the scholar's opinion, they didn't reach to a unified solution concerning criteria of preponderant part. They tried to compare with the wording of Article 3.1 of CISG, and they put a test. They said that the test under Article 3.2 of CISG should be stricter to render CISG inapplicable. For example, scholars underline, Herbert, Honnold, all of them consider the service element is a preponderant part of the contract if the share of service part clearly exceed 50% of the total value of the seller's obligation. This is not the opinion of Franco Ferrari, who considers the service element even it couldn't exceed 50% of the total value of the contract. On the other side, we have German court in Munich stated that an approximately identical value of the different obligation, goods or service, is sufficient to render the convention applicable. Value of each element is not the sole criteria to be considered here. Purchasing parties' particular interest should be taken into account when the court states the preponderant part of the contract. And here we are going to note the effect of the national legal provision. The third requirement to apply CISG is the subject matter of the contract, which is supposed to be goods. Term of goods hasn't been defined by CISG, but goods in essence of the CISG, according to different scholars and courts, are movables, tangible objects. Concept of goods should be interpreted widely. Why? To absorb different innovation recently. Except types of goods excluded expressly from the scope of CISG by Article 2, such as vessels and electricity and so on, flexibility of CISG rules entitles scholars, courts, or arbitral tribunal to extend concept of goods to all movables or tangible objects, with a wider interpretation of term goods. This wider interpretation could be based on Article 7 and 8 of CISG. These articles open the door for wider interpretation, considering general principles of international commerce and intention of contracting parties. Product relates to modern technology require wider interpretation of goods too. For example, wide interpretation mechanisms serve properly with matters such as know-how and software. Matters of software, it was new a few years ago, but now it's a little bit tradition. Sales of know-how, which is not incorporated in a physical or electronic medium, wouldn't subject to CISG and vice versa. But sale of software subject to CISG as long as software is materialized in some form, CD, for example. We are still in the classic notion of goods still here. But sale of software may subject to CISG, even software transmitted electronically, free of any materialized form. This is the modern notion of CISG, of goods in CISG, and it's based on general principles and intention of the parties, according to Article 7 and 8. What about transfer of rights and technology required to use the sold goods? A famous question addressed now by all participants in this moot. Transfer of rights and technology required to use the goods may change the nature of the contract of sale or not. Actually, this question needs a lot of discussion because the proper use of goods may require additional rights to be transferred to the buyer. For example, IP rights, licenses. Actually, additional rights or license with delivery of goods constitute bundle of rights necessary for the use of goods. This additional right or license included in the contract, but may not prevent the contract from being a selling goods contract for the purpose of CISG. A respective goods produced specially for the buyer or not, bundle of rights may not change the nature of the contract, as such right or license are necessary for the proper use of the goods. The second gray area in CISG scope of application concerning the legal scope of application. Different points of contact with national laws has been created due to the limited scope of application, legal scope of application of CISG. The legal scope of application of CISG stated in Article 4, saying that CISG govern only the formation of the contract of sale and the rights and obligation of seller and buyer. This article excludes expressly the validity of the contract and the effects of transfer of property from the scope of application of CISG. But this is not only the points excluded from the legal scope of application of CISG. This article contains positive and negative definitions of CISG legal scope of application. CISG govern only the formation of the contract and the obligation of contracting parties, buyer and seller. The validity of contract and the transfer of property excluded expressly. Also, personal injury and death excluded from the convention by Article 5. But practice declared several matters excluded from CISG legal scope of application and consequently governed by national law and entitled courts or arbitral tribunal to influence the application of CISG by their own legal traditions. That limited legal scope of application of CISG entitled UNICETRA to enlarge the number of member states, but it also, and avoid the point of weakness of the previous two conventions of Hague, but in the same time, it entitled national legal tradition to play an important role for matters excluded from the application of CISG, such as validity of contract, mistakes, misrepresentation, fraud at the time of forming the contract. All these matters couldn't be governed by the CISG. There is no text for it, so it should be governed by national laws. Liability of tort. One of the most important points in international sale of goods, pre-contractual liability. In many cases, negotiations stopped for no reason. So what about the pre-contractual liability in such case? It's not covered by CISG. So you have to look for any rule in national laws. Prescription of rights. Different matter also excluded directly or impliedly from legal scope of application of CIG. And to cover it, we have to look for a solution in national laws. CIG Chapter 2 provide a general principle to guarantee minimum limits of unified rules concerning matter excluded from legal scope of application of the convention. The national legal traditions still play a role in different matters, especially for pre-contractual liability, because I deal with this matter directly, and I note how far different countries do concerning this matter. Actually, CIG general principles was an attempt to unify practice in matter executed from CIG. They try to reduce the influence of national legal tradition in this regard. But using general principle of CIG to deal with matter excluded expressly or impliedly from the legal scope of application of CIG is quite frequent in courts, arbitration, or in academic writing. For example, principle of party autonomy, principle of freedom of form, principle of favor contractus, meaning the avoidance of contract should only be granted as a last resort, principle of full compensation, principle concerning the burden of proof. This principle governed by some articles in CIG, for example, 25 and 79. But the basic rule, the party who wants to use a provision of CIG in order to gain advantage from it has to prove that the factual precondition of that provision are met. But other matters concerning evidence governed by national law. Even I have a main principle in CIG, different matters, different detailed matters should be governed by national laws. As a conclusion, I have to confess that CIG limited scope of application was intended by drafters just to entitle as much as possible of countries to ratify the convention. This matter of this strategy entitled unilateral committee to get more member states for the convention, but it opens the door for more national legal tradition to dominate the application of CIG. Second, the modern technology play an important role towards more flexible interpretation of CIG rules concerning the requirement of application, especially the requirement of internationality and the require of goods. Terms such as goods, sale, place of business should be interpreted widely to realize more compatibility between CIG rules and recent innovation in international commerce. Fifth, general principles provided by CIG rule guarantee minimum limits of unified rules concerning matter executed from legal scope of application of the convention. The national legal tradition still plays role in international commerce due to limited scope of application of CIG. Finally, please permit me to address an important question by the end. Regarding the common legal background and the common traditional legal thoughts of Arab countries, comparing CIG member states, of course, can we reach once in a day to Arab conventions on regional sale of goods? Thank you very much for your attention.
Thank you, Professor Amal, for that very informative and detailed presentation. I'm not sure if you could hear us, but there was an applause for you here. I don't know if the mics work inside the room. But thank you very much for your presentation. Now I believe we are breaking for lunch, and we'll be back at 4 p.m. So thank you very much.
الوقت طبعا مزنوق شويه معلش. انا بص، انا لو انتوا حتى حبيتوا انكم تكملوا انا 5 لازم اقوم اصلا، عندي للاسف ويبينار هتكلم فيه. لو في سؤال او حاجه انا هقول لهم، يعني في سؤال او حاجه يسالوكم ممكن نفتح بانل ديسكشن، كان مودريت بعديه وخلاص. اوكي. Yes.
Okay. Welcome back, everybody. Our next session will be on the joinder of third parties in arbitration and ambiguous relationship. The panel will include Dr. Ismail Salim. Dr. Ismail Salim is the director of CRCICA and the secretary treasurer of the IFCAI and vice president of the Egypt branch of the CIR. Dr. Salim is frequently appointed in arbitral tribunals and as sole arbitrator in proceedings under various rules, including CRCICA, ICC, DIFC, LCIA, and UNCITRAL. To name a few, Dr. Salim teaches private international law at IDAI, Paris 1 Panthéon-Sorbonne, and Cairo University, where I had the privilege of being his student. He also teaches comparative international arbitration law at Paris 1's Middle East Laws LLM in Paris. The panel will also include Professor Dr. Mohammed Abdel Wahab. Professor Abdel Wahab is a founding partner and head of international arbitration, construction, energy groups at Zulfikar and Partners, as well as being the chair of the private international. You can skip me. It would take very long, I suppose.
As a matter to save time for the
Save time? Okay, no problem. Thank you. Skip you all. I can just say your names then. There will also be Mr. Girgis Abdel Shahid and Mr. Mohammed Osama.
Thank you very much, Malak. So it will be my pleasure to moderate this session. I have agreed with the panelists that it is going to be a panel discussion. And I hope this will make this session much more interactive. So I will start with the notion of joinder in arbitration. What is the notion of joinder in arbitration? And I'm asking Mr. Mohammed Osama to start by responding to this question. Then I will ask Mr. Girgis, why is joinder useful in arbitration proceedings, and in what are the cases where joinder is often requested?
Thank you, Dr. Salim. It's a pleasure to be here with you all today, especially given the ongoing circumstances with COVID-19. And I thank the center for arranging for the venue. Always very generous with promoting arbitration-related activities in Egypt, and we look forward to future events. With respect to the notion of joinder, I guess the first relevant issue or question to ask ourselves is why is it relevant, and why do parties even have to deal with it in a context of arbitration, whether inside Egypt or outside. So if we think of the relevance of the issue, I think it pertains to the consensual nature of arbitration, right? Because if we're dealing with a contract that is signed between party A and party B that has an arbitration clause within it, then it's it is for us to assume that any arbitration related to this contract would have to be between party A and party B. But the question is not as, the answer to this question is not as direct and straightforward as many things in law, I would have to say, are. And the reason for that is, again, when we go back to the consensual nature of arbitration, consensual does not translate into signing, right? Into signature. It translates into consent. And consent can be achieved through different ways in law. And that could be whether implied consent, by participating in performing the contract and being notified of the existence of an arbitration agreement related thereto. It could be also through doctrines that deal with surpassing a corporate personality and piercing the corporate veil. We also have the doctrine of the group of companies. So we have a lot of ideas and theories and doctrines that deal with this idea, to expand it, to make sure that whenever there is an agreement to arbitrate, it must be honored. I won't take long before I pass the mic to Dr. Abdul Wahab, but I want to say to address the reason why this issue is very relevant in arbitration. And I think one of the reasons for that relevance is that, you know, due to the existence of sophisticated clients, you know, they when they instruct or approach a lawyer or a firm, they don't only care about the process and how it will unfold until they get a piece of paper, you know, entitled an final arbitral award. They care also about, or even more, about how to enforce that piece of paper. So if they're gonna invest lots of funds to finance on arbitral proceedings, they want to make sure that at the end of the day, they're gonna enforce against the party that has assets. So if they're dealing with, the other party is merely a shell company that doesn't have any assets, then why would they invest in the process unless arbitration and the you know, jurisprudence, awards, and court rulings support the idea of acknowledging, enforcing an implied agreement to arbitrate, or even through the doctrines I've mentioned previously, to bind the party to an arbitration without it signing it, or, you know, piercing the corporate veil and the other doctrines related to that area. I'll pass the mic to Dr. Abdul Wahab.
Sorry, Girgis, do you want to add something?
Sure, unless Muhammad insists on Dr. Abdul Wahab saying
I'm happy to surrender my surname to you if it's not insulting to you.
I'm sure they would have enjoyed Dr. Abdul Wahab than me, but you're stuck with me for 2 minutes. Joinder exists in law in courts because it is important, it is useful, it gets the job done. So joinder has been there in courts for many years and for a particular reason. The only thing now that this being discussed is why won't joinder as well be part of arbitration? And the main conflict of that is the party autonomy, which is sometimes used as the big baba, and otherwise it has to be understood in the concept. If you agree to arbitration in general, then you are accepting the concept of commercializing your dispute and wanting to reach a quicker and fairer solution. So if we talk about usefulness, it is the same things as to why joinder is important in courts as well, because it removes the risk of inconsistent awards or findings. It alleviates multiple actions. It could be a very cost-efficient way of resolving matters. So party autonomy has to be respected, yes, but party autonomy should be balanced with the party's interest and efficiency of dispute adjudication. Where is it useful? When is it often requested? Think about mainly or primarily construction contracts. You have the contracts between the employer and the main contractor. The main contractor has a subcontractor, and the subcontractor has another subcontractor. All of these most likely have arbitration clauses in their contracts, and these matters trickle down. So when the employer sues the contractor, it could be because of the fault of the subcontractor, who in turn is reliant on a fault by a subcontractor. So imagine that a tribunal at the very end says that the subcontractor is not at fault. However, at the very end of the line, another tribunal says it is because of kind of the fault of the subcontractor, but the facts are not really completely at that level. So multiple conflicting awards come out of this. A lot of investment transaction now, sophisticated transactions happen in the financial world, whereby a company acquires a holding company, and then a holding company comes in to acquire the bonds from a different location, and then multiple jurisdictions are at place. However, similarity of arbitration clauses, at the end of the day, if they are bundled together, we come out with a very useful and cost-efficient way of resolving matters. Thank you.
Thank you, Girgis, or Mr. Abd Shahid. Now, I want to ask a question. Joinder may take place prior to the constitution of the arbitral tribunal and may, under some rules of some institution, may also take place after the constitution of the arbitral tribunal, so prior or after. My next question concerns the situation prior to the constitution of the arbitral tribunal. What stance does institutions such as ICC and SIAC take when dealing with joinder? And I ask Professor Abdelwahab to respond to this question.
Thank you very much. Few points. It's a pleasure, of course, to be here, and I concur with my colleagues who have enlightened us on the issue of joinder. Let's not forget that the contours of consent is redefined and reconfigured globally. It is no longer purely a function of consent when we talk about joinder of third parties. In many legal systems, there are elements that are law-oriented. Think of universal succession, novation, assignment. Things like that are not normally just consent-based. In terms of the timing of considering whether joinder would take place before the constitution of the tribunal or after, and I understand that Dr. Ismail is asking purely in relation to the institutional test before the joinder, before the constitution of the tribunal. The key word is the prima facie test. That is the key word. So institutions as administrative organizations just administering the proceedings are not taking judicial decisions on joinder. They are making or taking a prima facie look at the joinder. At the ICC specifically, there was a long-standing rule that the drawing line in terms of the fine line where joinder will not be accepted was the constitution of the tribunal because of a history relating to the Dutco case, where a party can be a third party can be a party to the arbitration to the extent they contributed or participated in the constitution of the tribunal. It's more of a French-focused approach, not necessarily globally shared in many other jurisdictions, but because of that, that was the view. Before the constitution, you can apply. If accepted, they will participate in the constitution of the tribunal. Since 2021, and even before that in the rules in 2017, there was a slight amendment before 2021, whereby if all parties agree, the third party can be joined, assuming they accept the constitution of the tribunal and the terms of reference, if applicable. Now, since 2021, there has been a further modification whereby you may exceptionally join a third party without the consent of all parties to the extent that the third party accepts the constitution of the tribunal and accepts the TOR if applicable. That is the current ICC test in this respect, because there has been situations where it was warranted that a third party requested to join for certain interests or requested to join for certain interests. And so in that sense, in a very narrow perspective of cases, this was acceptable and takes place. Now, SIAC is a little bit different in a way. SIAC, we know they have their amendments in 2016. There's the SIAC rules, and SIAC and HKIAC actually are very similar in this regard. One is Article 27 and the other one is Rule 6. In the HKIAC in Hong Kong, they have in Article 27, 14 paragraphs dealing with joinder. 27.1 to 27.14 deals with joinder, which is amongst the most elaborate provisions in the world regarding joinder in this respect. And SIAC as well has in Rule 6 the same, more or less, about 14 paragraphs. The test there as well, again, they can participate in the constitution of the tribunal, but it's not a must, because both HKIAC and SIAC include an express provision, one of the latest paragraphs, which says, assuming the third party is joined, they would be deemed to have waived their objection to the constitution of the tribunal. So there is a deemed waiver, either express or implied. The only distinction I would make between HKIAC and SIAC in Singapore is something that people do not normally consider carefully and overlook, which is HKIAC referred to an explicit consent, express agreement. SIAC refers to consent without reference to express, which opens the door for consent by conduct or implicitly. I will stop here unless you ask me to address it further.
Thank you very much, Dr. Abdelwahab. Now we will deal with joinder based on a party's request to join a third party versus a third party at its own initiative wishing to be joined in arbitral proceedings. So my question to Mr. Osama, prior to the constitution of the arbitral tribunal, is it possible for a non-party wishing to join an arbitration case on its own initiative to submit a request to the arbitral institution to be joined? So you will respond to this question, and Dr. Abdul Wahab will add where necessary.
The answer, again, since we're dealing with institutional arbitrations, is, the first step we do is go to the institutional rules and see what they say, what they have to say about this matter. For example, if we go to the Hong Kong Center's rules, we'll find that, again, as Professor Abdul Wahab mentioned, they have a very elaborate, detailed regulation of this matter. And we have an independent paragraph inside the clause that says that, yes, a third party can indeed request its joinder before the constitution of the arbitral tribunal. And this, I would say, in practice would bring into question, whether when the request is submitted to the center and before the constitution of the tribunal, and the center makes a decision on that request. Again, given the administrative nature of the center's role in the matter, the tribunal would have, if asked, to decide on this matter and whether that was a valid joinder or not. That's it from my side. Thank you.
Thank you very much. Before I give you the floor, I want to say something about Article 4.2 of the Swiss rules.
Happy to do so.
Because I would like to ask Dr. Abdul Wahab about this article, because this article, Article 4.2 of the Swiss rules, opens the door for both the joinder and what we can call the intervention. So a party wishing to intervene and versus a party, a third party wishing to intervene versus a third party joined by virtue of a request from a party to the arbitration. And this article does not require, contrary, for example, to CRCICA and UNCITRA rules, this article of the Swiss rules, Article 4.2, does not require that the third party to be joined or the third party which will intervene be a party to the arbitration agreement. So what is the silence of Article 4.2 of the Swiss rule? Does it mean that under the Swiss rules, we can join or we can permit an intervention by a third party that is not a party to the arbitration agreement? Thank you.
Perhaps, if to put some context, if we were to map the provisions dealing with joinder globally, I would divide them into three categories. Rules that are quite stringent on joinder, example, ICC, stuff like that, especially after the tribunal is constituted. Rules that are moderately flexible. The ancestral comes, and of course, the rules or the institutions which the ancestral rules have inspired, like the Cairo Regional Center, paragraph 17.6 in the Cairo Regional Center rule and 17.5 in the ancestral 2013 rules, where you have the option there. You're not restrained by the idea that the tribunal is constituted so you cannot join a third party. Not at all. You can indeed do so. And then the most liberal rules on the other side basically would be the Swiss rules. And by the way, the Milan Chamber rules of 2020 in Article 25.7 of it. So 4.2 and 25.7, the Milan and the Swiss. The Swiss rules, by the way, are 2012. The Milan is 2020. Their amendments took effect in January 2020. The only difference, they have the same wording, word for word, except one difference, which is an amendment in the Swiss rules referring, or let's say substituting the reference to third parties by using third persons, which is the CRCICA wording from the ancestral. So the Swiss rules have changed the reference to third parties, to third persons, whereas the Milan continues to refer to third parties as such. The idea behind the Swiss rule, of course, it may come across as a door wide open to join third parties? Not necessarily the case, not at all. The idea is that it refers to the possibility of joining third parties distinctively from the constitution of the tribunal, if the circumstances so warrant. The twist in the Swiss rules is that they make a distinction between joining a third person to become offensively a party making claims, or defensively a party against whom claims are made, and a silent third party where you do not have claims for or against. And that is an important point for those prosecuting arbitrations under the Swiss rules. Because in many other institutions, to join a third party, the immediate response from the other side is that you want to have a claim. Is that a claim you're making against us? Is that a claim that party is making? So you can have them as a cross-claimant, counter-claimant, respondent, whatever. Whereas in the Swiss rules, it's not necessarily the case. You may have a party join, and they call it a side intervention, where that party is a silent or supporting party to one of the parties. Think of it in this way, to give an example. A dispute between shareholders that results in impacting the shares in a company. They would join the company, even though no claims will be made against the company, because they want to enforce the award on the shares so that the company complies with the award in that sense. So that is a clear example. Under the Swiss law, you will have a dormant third party joined in that sense as supporter, as side intervention, or whatever the case may be. The other point is that there is a Swiss specific rule which people also overlook about set-off. Under Swiss law and in Swiss arbitrations, if you have a set-off, it does not necessarily need to arise from the same contract, the same arbitration agreement, or the same transaction. You can assert a set-off substantively, provided you fulfill the conditions of set-off under Swiss law, and you can request the joinder, or the party claiming set-off can be joined under a separate arbitration agreement or a separate contract. So, but the caveat there is that it must not be a contract including an irreconcilable arbitration clause that is not consistent. So if it's an agreement providing for a different institution, you can't join them. But if it's similar or compatibly similar in a way, then they can be joined on the basis of this possibility as well. And this is a very interesting point where there is a spillover from the substantive element of set-off to join procedurally a party in this respect. So the Swiss rule is liberal. The Italian mimics that, the only difference referring to third parties and third persons, which on the practicality of things doesn't turn out much. But it is indeed a provision. And it's just one paragraph, whereas we see under the HKISC and SIAC about 14 paragraphs dealing with issues of joinder in this respect.
Thank you very much, Professor Abdelwahab. Now, Mr. Abdel Shahid, I will ask you the next question. What happens when the institution takes a decision to reject a request for joinder of an additional party prior to the constitutional of an arbitral tribunal? Can such a decision of joinder be reversed by the constituted arbitral tribunal dealing when such a request is raised once again by the same party?
The answer that I hate is that it depends on the rules. So it definitely depends. So let's see the ICC, for example, on the before and after. The before ICC rules, before January 2021, I would say the answer is no. It's totally in the hand of the Secretariat and the court to decide on the joinder part, because once the arbitration tribunal is constituted, there was no room in the rules for anyone to apply for a joinder. However, what about now? Now there is room. The rules allow for it. So if the parties agree to ICC rules, there is room for an application to be made to the arbitral tribunal. And here is where the catch-22 is, because the test for the tribunal is somehow quite similar to what the Secretariat and the ICC court would do. This would be one of the first times you would hear that the court or itself applies the same test as the arbitral tribunal from the very beginning, which is the prima facie test. At the very beginning, the arbitral tribunal has to look, among other things, it's more actually, is the prima facie test. So the question becomes whether the prima facie test of the Secretariat and the court different from the arbitral tribunal, is it wider or not? This is a question that is yet to be seen. I believe that the arbitral tribunal has more autonomy to apply this prima facie test, and they can actually see more restrictive rules to include, and that is around the surrounding circumstances of the joinder. So the relevant circumstances of the joinder, the timing, conflict of interest, impact on the timetable, multiple other things that the arbitral tribunal has to see, observe, and determine, which is quite different than the Secretariat and the court.
Thank you. Do you have something to add? Perhaps
just-
another institution?
No, just briefly, I will say in the overwhelming majority of institutions, and I agree with my dear colleague, Mr. Girgis on this point, the ICC aside, at least prior to 2021, institutional rules normally or decisions do not have a res judicata effect and do not bind tribunals. The twist practically, and that's something not to be taken lightly, is that institutions have to be extra cautious when taking a decision about rejecting or accepting. The reason being, and that goes to the cultural background of arbitrators, their gravitas and their experience. Some arbitrators, and I'll be very candid, if this is your first case in a major institution and the institution said, we don't believe there is a prima facie case, psychologically, the inclination, you would not want to oppose the institution. Whereas the institutional rules allow you to do so, but it's just a psychological barrier that you would ask yourself, well, surely they must not have got it wrong. That should not be the test. And that's my advice to anyone sitting in a case. You have the full authority as a tribunal to look into the fact. Remember that institutions do this on a prima facie test and prima facie basis. You can take then a different position. That's my first point. The second point practically is that institutions, and again, this goes to the point that institutions should be extra cautious. A party now caught up into the proceedings is fighting their way out. Whereas a party who is not joined is going to be fought to have them joined. And this carries with it a threshold regarding the burden of proof. If you want to convince the tribunal that the institution got it wrong, or not necessarily got it wrong, but did not have all the evidence before it at the time, so presumably the evidence would support the joinder, you're doing this and you have an extra job compared to a situation where the party is already locked and is fighting to get out of the proceedings. So these are the two takeaways practically that I would just highlight. Before the arbitral tribunal. Because if the institution took the decision to join the party and that party is joined, but it is objecting to the joinder, it will continue to fight the case. But fighting the case where you are in is different from fighting a request for joinder where you are not a party to the proceedings. Yes, if the tribunal, not the institution.
I'm sorry, who would be fighting the decision before the court and the council?
So you're saying the institution took the decision that there is a prima facie no case for joinder, and then the tribunal says yes or no, that there is none. Then your only option is in courts then. But then you have to consider whether in the jurisdiction in which you're going to fight this, there is basis to do so. And we can discuss because, for example, there is one case under Egyptian law which went back and forth between the Court of Cassation and the Court of Appeal twice, where the tribunal decided not to agree to the joinder of third parties that were jointly and severally liable debtors. And so the court said, we're not going to set aside the award. The tribunal's finding stands for all good reasons. When it went to the Court of Cassation, they told them these are jointly and severally liable debtors. You cannot accept some and refuse the others. They remanded the case back to the Court of Appeal. The Court of Appeal, for the second time with a different circuit, told them, we're not going to comply with what the Court of Cassation said. We are not going to set aside the award. And it went back to the Court of Cassation, and the Court of Cassation, understandably, is going to set aside, because it's a second time review, set aside on the basis joint and several liability.
Thank you very much. Another question is, and now I ask Mr. Osama about the effect of joinder of a party after the constitution of the arbitral tribunal. So shall the tribunal be reconstituted by applying multi-party provisions?
Again, the answer depends on the rules, the applicable rules. So we need to see which institution we're dealing with, and we go to the rules and check. For instance, with respect to the Hong Kong Center, they have an explicit provision that says, in case a joinder is accepted, the parties, all of them, are deemed to have waived their rights to appoint arbitrators, and the Hong Kong Center itself would have control over the appointment of the arbitrators. So we'll see here, when we examine other examples, that the Hong Kong Center opted for a harsh but can be argued to be practical approach. It ended the story if joinder is approved, and so we have more than two parties. How are we going to appoint the arbitrators? It's up to us as a center to decide how to appoint. When we go to other institutions, such as the Cairo Regional Center, and if we go to the UNICETRAL rules or the LCIA rules, we'll see that they, despite different minor difference in wording, they've opted for a different, more flexible, more party-friendly approach. They say basically, you, the parties, have the right to agree. If you don't agree, it will be up to us. Thank you.
Professor Abdulwahab?
Yes, I had understood your question to mean once the tribunal is constituted. Yes. So if constitution is finalized, that's it. It's a done deal. You can't add another arbitrator. And as my esteemed colleague, Mr. Osama has mentioned, HKIAC, SIAC, they have an express provision which says there is a deemed waiver of objection to the tribunal in this respect. You can either consent voluntarily or it's a deemed waiver, and by agreeing to the rules, you accept that this is a deemed waiver. So you're not going to reconstitute the tribunal as such. That's the first point. The other point I would make is that vice versa, which is a very problematic scenario, assuming a third party is joined, they participated in the constitution of the tribunal, consider the ICC case situation, and then the tribunal comes and says that party should not have been joined and now exits. So instead of having a 5-member tribunal, the arbitrator appointed by that party is facing a destiny of likelihood of being removed because that arbitrator is no longer then appointed. Anyway, what I want to say conceptually, and I think institutions and globally arbitration scholars need to reconsider this. We tend to overlook the fact that arbitrators do not represent parties. Arbitrators do not represent interests of parties. It is counsel that do so. So the idea of a fact that we may, as parties, have conflicting and competing interests, which may result in a situation that you appointing an arbitrator and me appointing another arbitrator, as a matter of fact and law, have no bearing on the arbitral tribunal's inclinations, because with the competing interests of the parties, that carries with it a perceived autonomy to appoint your own arbitrator, has no impact because the arbitrator is not representing any of those competing or conflicting interests. So the test of appointing different arbitrators on the basis of conflicting interests is a false alarm and a false test. The test is one about equality of arms, as the Datku case. You had the right to appoint. I should have an equal right to appoint. Bear in mind that you have a situation where we have unilateral arbitration clauses or asymmetric arbitration clauses, whereby one party can only appoint the full tribunal or one member of the tribunal, or the other party appointing 2 or 3 or whatever. And in certain jurisdictions, the test then is that valid or not? Now, we know in a number of jurisdictions this may not be the case. Let's take France, for example, as a situation, which, by the way, invited the ICC to reconsider one of its provisions, again entered into force in January 2021, about the fairness of constitution of the tribunal. And the background to this, you had 5 parties to a contract. 4 members of the same group and 1 opposing party. And they said, we are going to appoint, let's say, 5 members of the tribunal. 3 will be appointed by these companies and 1 by the other side. So this creates a sort of disequilibrium from the perspective of some legal systems that invites the court to reconsider the constitution in this respect. But once the tribunal is constituted and joinder is permitted in a post-constitution scenario, the tribunal will continue forward with its case in this regard.
I think also in practice, the situation could get more complicated because again, putting aside the institutional rules, if we go back to the source of the arbitration, which is the agreement of the agreement to arbitrate, and we find the wording each party, and bear in mind that we're dealing here with the contract between 2 parties, so each party shall appoint an arbitrator. So each party here becomes a problematic issue, in my opinion, when we're dealing with a post-constitution of the tribunal, and we're dealing with an accepted and approved joinder request, because in that case, the party that successfully joined the proceedings could be in a neutral position as to the other already existing parties. It might side with one of them, or it might take a totally independent stance. So in this regard, I would say in practice we've seen it. There would be a battle between the 2 already existing parties who already appointed co-arbitrators, and the newly joined party that wants and is very interested in having an arbitrator appointed by it. So in practice, it gets very complicated, and I would say we'll have to wait and see how tribunals deal with these intricate issues, because again, depending on the law of the seat of arbitration, and the issue of joinder in general could be subject to review by the local court.
Thank you very much, Mr. Osama, and before I open the discussions of the floor, I would like to add that we as CRCICA, when we apply Article 17.6, we refer to the travaux préparatoires of Article 17.5 of the UNCITRAL rules, because they are identical. Article 17.6 and 17.5 of UNCITRAL versus CRCICA rules are identical. So in the travaux préparatoires of Article 17.5, it is explicitly mentioned that if a third party to the proceedings, or a third person to the proceedings, is joined, of course, this third person to the proceedings should be a party to the arbitration agreement. So if such third person is joined, it does not have the right to request the reconstitution of the arbitral tribunal, because the proceedings might become multi-party proceedings if at the outset the proceedings were between only 2 parties. So such joint party does not have a right to reconstitute the arbitral tribunal or to appoint an arbitrator. And the justification, as mentioned in the travaux préparatoires, is that this third person is indeed a party to the arbitration agreement, and by consenting to the UNCITRAL rules, there is an expectation that such consenting party to the arbitration agreement may be joined at a later stage after the constitution of the arbitral tribunal, and in this case, such party will not have the right to request the reconstitution of the arbitral tribunal if it has consented to the UNCITRAL rules. Mr. Al-Shaid?
Yeah, if I may say that as we see things are evolving, actually, there is a lot of flexibility happening in the arbitration world to encompass multiple other concepts that were thought years ago only applicable to the judicial system. However, now arbitration is evolving, and from that evolution, you can see that there is now competition between institutions, if I may call it this way. The more flexible and encompassing your rules are, the more attractive as rules you will be to the parties signing contracts. Of course, we will have this conflict of between corporate lawyers or transactional lawyers and arbitration lawyers not being asked their colleagues about which is the best arbitration clause to put in the contract when they are transacting. However, at the end of the day, it is us that create this evolution, and it is our pressure that puts the pressure on the institutions and the laws and the national courts to evolve and create new laws and new precedents. Finally, there is the back door of joinder if the rules do not allow joinder, which is the extension of the arbitration clause. Right now, it's maybe confined to a group of companies piercing the corporate veil and the like. However, who knows? Maybe extension can happen way and beyond other concepts of this sort. It is us that creates these concepts that is ultimately accepted by courts and institutions. So we have to keep the pressure. Thank you very much.
You want to say something before I open?
No, let's hear what they have to say. We can answer during the
we have
Q&A.
now until 5 o'clock because I really want to stick with the timeline. I know this session, I'm certain this session is very interesting, but please, we will stick to the timeline. So Mr. Ibrahim Shahata.
Arbitration laws on the joinder of third parties. So how would you resolve that, for example, in Egypt?
Let me kick off by this by saying the following. Not all arbitration laws. For example, we have, and that's a very good question. Thank you, Ibrahim. We have, for example, the English Arbitration Act of 1996, where we have Section 82, which refers to the definition of a party, claiming under or through a party to the arbitration. So there are, though these provisions are quite sparse and are not proliferating across the globe. Of course, in ad hoc arbitration, the prime example is ancestral-based model. And in an ancestral-based model, two things happen. You don't have likely a prima facie test because there's no institution. You have a tribunal-based test, which is based in Article 17.5 of the ancestral rules. And they will look at the consent. But bear in mind, when we look at the consent, as we mentioned, because there are law-oriented concepts and doctrines, is that you look at the timing of the request, the jurisdiction of the tribunal, and that's, by the way, another misconception, because Article 4.2 of the Swiss rules does not create jurisdiction of a party that is not bound by arbitration. It only broadens the scope of interpretation potentially of who is a party and how to create an opportunity to join a party, assuming the tribunal has jurisdiction. So if you look at the jurisdiction, you look at the timing, you look at the competing prejudice that may result as or may ensue as a result of the joinder. And once the tribunal is satisfied about that, then as a matter of fact, joinder can be assessed properly. There is one additional element that is included in the ICC rules, which is situations of conflict of interest. And this is a very interesting area, those who want to do further research in that, which is you have appointed the tribunal members have cleared conflicts. The joinder of the third party will create a conflict to one or more members of the tribunal. Would you put the interests of the tribunal members and the integrity of maintaining the tribunal in place ahead of the interests of the parties in terms of joining a third party? It's one of the tests that goes into the analysis. And without leaving you without an answer, I'll tell you the following. Maintaining the integrity of the proceedings and the constitution of the tribunal is a prime directive in a way. So if that creates a conflict, then you have created a situation where you have appointed arbitrators, knowingly or not, that may result in them taking a decision to avoid joining a third party to avoid conflict, unless, of course, the parties have agreed. And we see now reiterations of this, not just in relation to parties, but to counsel. The LCIA, for example, which also has jointer provisions under Article 22.1.10 Roman, which is X, also addresses joinder in this respect. And they provide for an opportunity that you may exclude counsel if they change counsel during the proceedings, if that creates potential conflict to the tribunal or actual conflict. And the ICC, amongst the amendments as well, included that feature which was standard in many terms of reference. So what I want to say basically is that a lot of let's say elements go into the mix when assessing and considering joinder or extension of arbitration clauses requests, and tribunals need to be very careful. And I must say, if you have a case where you have an element of joinder, be careful, because you need to have good arbitrators who understand, and good counsel, I have to say, who understand how joinder works and how it should be assessed and verified, because otherwise it could be a frustrating experience and could be a very time consuming and much less cost effective approach in this respect. Thank you, Ibrahim.
You want to add?
No, it's I would go to the last point of good counsel is what expands the horizon and interpretation, because at the end of the day, if you have the good argument to expand the interpretation of a certain particular law, a judge will ultimately read it the way this good interpretation will meet, and this is what creates law by case precedent. And we have seen that our Court of Cassation recently is actually evolving the law by creating case precedent and interpreting the law in a more liberal way. So we should keep on pushing this by good counsel.
But when it comes to Egyptian domestic arbitration under the law number 27 for the 1994, I think this is your question. So of course, this law does not contain any provision regulating intervention or joinder. So, and the Egyptian Code of Civil and Commercial Procedures is not the Lex Generalis, Sharia al-Amma, is not the Lex Generalis of arbitration, because this is, it is not the Lex Generalis.
ممكن يبقى Lex Luthor بتاع سوبرمان. Yes.
So, yes. But yes, a domestic tribunal or
one thing I have to say when it comes to the Egyptian Arbitration Act, it is high time that people abandon the slogan, which is now a misconception, that arbitration is an exception. This has caused and continues to cause so many problems, cited by counsel on both sides. We have one, by the way, decision from a court of appeal years ago, and it says arbitration is the natural judge for disputes. But the point is, we are born into the world where exception means that you construe provisions narrowly and you do not subject them to analogy. And to that extent, this has been used and abused, I must say, to be fair, to both camps, in a way that has spun the discussion about joinder and many other aspects of arbitration agreement, including the interpretation of the arbitration agreement itself, out of context. And I think everyone agrees that, practically speaking, arbitration is quite normative. So it is time that the Court of Cassation, I think, needs to take the lead, since they have taken the lead, at least in the past few years, about elevating the jurisprudence across the spectrum of legal matters in Egypt, not just arbitration. And I commend them for the excellent effort that, and we will seek Councillor Nabil Omran in the next panel. I think much work has been done, and it's now high time to abandon this reference to exception, because it is a hollow slogan that is not befitting of the practice of arbitration now. Now, that is not an invitation from my side to say that bad arbitral awards to stand, that you take parties to arbitration without an arbitration agreement, not at all. It is simply in the context of referring to arbitration as an exception when an arbitration agreement exists.
Any other question? Audrey, and then you.
I am happy to take it, and I fully understood your question, which is a very complicated one, and I like it. And let me say the following. The first point I've identified, you said against its will, and I heard you carefully. We have to take that with a grain of salt, because against its will, remember that it's only expressing its will in a post-arbitration situation. Whereas we're looking at the will at the time of the transaction, at the time of the agreement. So it matters not that you have changed your views later on or deemed to have done so. So that's the first part. Secondly, the risks. Now, the Swiss example is interesting, of course. And as I mentioned, Swiss, the Milan, the Egyptian example and stuff. The jurisprudence in these jurisdictions has evolved to say the tribunal is the lord of the proceedings in this respect. If the tribunal has decided one way or the other, then as a matter of fact, so be it, it's a decision. And there are parameters for setting aside, and they are limited in these jurisdictions. If you do not fall into one of them, the award will not be set aside and will not be declined enforcement or refused enforcement in a way. The risk of a defaulting respondent exists, and it exists even in a non-multi-party arbitration scenario. And just so you know, the importance of this topic we're discussing is that almost now 33% of cases worldwide are multi-party arbitration cases. And in that sense, you have that risk. But again, with good counsel, I think the last advice, or last say, good advice any counsel could give is that we should not participate. Because there is a uniform rule in almost all arbitration laws, all institutional rules, or ad hoc, including the answer trial, whereby if you have not objected, there is a deemed waiver. You can't use the court arsenal in a post-arbitration situation to challenge an award on procedural matters that you could have brought to the tribunal's attention on time. So it is not good advice that they remain dormant or silent. I think they should appear, they should make their objections, ensure that they are put on record, and then have the battle in court if that is the case. And let me say one thing about the culture. The culture in the overwhelming majority of jurisdictions regarding arbitration is that arbitral awards are voluntarily complied with. We just happen to be in a region, on a continent, where it is normative that parties will not comply. They will battle the case again in court. But this is, we have to accept that it is an alien to many cultures abroad where parties comply with arbitration awards. And that's my second request from the judiciary. If the judiciary, I'm not saying don't accept cases, accept them, but have cost implications. A party filing setting aside can do so, but then would bear the costs, including legal costs, substantially. So they will think twice, 3 times before filing for an action. If you don't have good prospects, that is a way of dealing with it. Allocate costs. But I'm now, the frustration of allocating 200 or 300 Egyptian pounds, the standard language used in judgments, no longer represents any standard of justice globally.
Thank you very much. I'm sorry, look, because we have to put an end to this very interesting session, but we have 15 minutes as a break. So if you want to ask any of the 3 distinguished panelists any question, yes. So what's your name? Shadden. Okay, thank you very much, Shadden, but I'm sorry, I have to apologize. We have to finalize the session. I must say, You're
conflicted.
So I'm very thankful to the 3 distinguished panelists. I think it was a very interesting session, and there is still a lot to say about joinder. And during this coffee break, you can certainly ask the distinguished panelists whatever question you wish to ask.
But let Shadden ask her question. What's the point about asking her name if you're not going to give her the chance to ask the question?
Okay. Okay, I will let Shadden ask the question, but may I leave?
No, of course,
okay.
We will go.
I will have to leave because I have a certain commitment, and Shadden is requested to ask her question. Thank you. Thank you very much. Yes, of course.
اوكي الطمع وحش بقى شفت بقى الطمع وحش قولي معاك
الدكتور بقى هتولى
خلاص ميرسي يا حبيبي
And for me, as a young aspiring practitioner, I wonder how an arbitral tribunal can strike.
Okay. I think you take me back to my first point of party autonomy is not a ba'ba or a taboo word, okay? It's like arbitration is an exception to the norm. It's all of these concepts, especially you as a young, evolving counsel, you should remove from your head completely and actually work on challenging every word of taboo there is, either culturally, by the way, and legally. So this is our job as counsel, to challenge the judiciary, for the judiciary to evolve itself and come up with the precedents that will ultimately lead to the betterness of the legal system. And this is the fairness. Back in the days, they used to say about lawyers, al-qada al-waqif, it is not a figure of speech. It is the efficiency of lawyers is what creates actual law, and the interaction between judges and lawyers is what creates evolved laws. And this is all what I have to say here.
It's a very interesting question, and I'll just say something specifically on implied consent, because for me, again, when we say implied consent, sometimes it's taken very broadly. Implied consent, for example, participating in the performance of a contract. But what about the arbitration agreement and the doctrine of severability and how that factors in? So in this specific example, I would say, but it doesn't apply to all cases, you would have to be very prudent as a tribunal when you consider implied consent, whether it extends to the arbitration agreement or not. In other instances, it can become more complicated, especially in terms of surpassing or bypassing the corporate personality and moving to attack principals and other affiliated companies. But again, these are different situations and must be dealt with different tools.
I join my colleagues wholeheartedly in what they mentioned, but let me add the following. I had understood your question to say, how can a tribunal reconcile what you perceive as an inherent tension between the doctrine of privity, fairness on one side, and joining third parties? I will answer this from Law 101 second year. You know that there is privity of contracts, right? Nevertheless, you accept that there is universal succession. You accept that there are permitted assigns in case of assignment. You accept third-party beneficiaries. You accept guarantors as potentially if there is joint and several liability of guarantors. These are all concepts that are perceived as standalone opportunities that would penetrate the doctrine of privity. In fact, would drive a quotient for into the privity for considerations that legislative authorities or legal systems considered to be of prime importance, overwhelmingly above and beyond the doctrine of privity in that sense. And these all apply in the context of arbitration. So there is no distinction there. But what we're saying is that consent and privity is no longer a static notion anymore. It is dynamic, as it's in a constant state of flux. And in that sense, you have to assess it at the time of evolution, to use Gerges's words, the stage of evolution within the legal system. And that's where the judiciary have a prominent role to play. And it goes to a fundamental philosophical question, is whether law is a leader or a follower in a society. نلك السؤالين كده. في واحد تاني فولو اب؟ قولي الفولو اب.
What is the scope or standard for the institution to decide on joinder, given that the nature of joinder requires
your question, you also used very important words. You said procedural and substantive. Institutions apply this. You have to know that joinder, an extension generally, involves a mix of fact-based and law-based elements. So it is a fact-sensitive exercise. Institutions are not going to decide the dispute on the merits. You need to select the most prominent arguments you have with whatever evidence you have to the institution to convince them to take a prima facie look and decide that there is sufficient evidence on joinder. If you succeed in doing so, that's fine. But do not think that it's a war, it's a battle, that the institution will go back and forth and there are submissions and you decide. No, the institution is just, what the institution is doing is trying to assess what case should go to the tribunal. And in that sense, you decide, you set the tone. And that's what I say, counsel is important. Because experienced counsel who know what they're doing, will go for the killer elements to convince the institution on a prima facie basis. The other party will keep objecting and will keep saying you can't, but then it becomes a question for the tribunal. So for the institution, you need to look at what elements, documentary evidence, presumably. Sometimes people go for witness statements, though rarely so, but it happens in many institutions. But I think the strongest thing you have is you submit documents that support why you think that party should be joined. And on what basis? There are jurisdictions within which institutions operate. Let's take England, for example. Group of companies is not acceptable under English law since Patterson Farms case, since Dalla case. You can't do that. And so the LCIA will not accept the possibility of joinder on this premise if you are arbitration seated in England. In Switzerland, group of companies is also not part of Swiss law, as liberal as it gets. But the caveat is that it's different from the English approach, because the Swiss perception of group of companies is as follows. Not because you are a member of a group of companies, you will be joined. You have to show us more evidence, either consent-based or law-based, to support the joinder. So you have to be careful what you argue, where, at what point in time, and in what jurisdiction.
And that's why counsel work starts with also the arbitrator that one nominates. The biggest mistake that clients sometimes do is come to you with an appointment already done, and then they ask you to continue with the job. Sometimes, a lot of times, we reject getting or accepting such a case because the fiasco starts from here. So counsel work is very important also from strategizing as to which culture this arbitrator comes from. And this is why we have the privilege of choosing arbitrators. It's not the must, it's not the most important thing that we have in arbitration. It's only a big bubble that sometimes people use about the choice of arbitrator, as Dr. Abdelwahab has said. However, it is a crucial part from the very get-go.
So what about if the procedural side is related to the substantive side? So one party is claiming that there is a claim and this claim cannot be solved. So in order to solve this claim, there should be a third party to join with the proceedings. So can the tribunal decide over the consent?
If I understand you correctly, and the word consent is not at the time of the arbitration. The word consent is that the arbitrator should be looking at is when the contracts and the transaction was happening. So this is back then, maybe years back then, and this is the homework that you have to do. It's not about now. There are actually a lot of arbitration clauses that are very apparent, and the defense mechanism is that I didn't sign it. So at the time of arbitrating is very different than what happens back then when they actually signed. So, and this is what they call contemporaneous facts and contemporaneous documents, and this is what you as an arbitrator need to look at.
I would add, if I got the question right, when you consider procedural and substantive issues in the context of a joinder request, you would basically, for the procedural issues, check what the rules say regarding the timing of submitting a request. Perhaps there's a deadline for submitting requests, so you'd have to make sure that the request is submitted on time to be accepted on form. Substantive issues in that context, again, they go to whether there exists legal basis for, saying that this party is also a party to the arbitration agreement. So it's important to differentiate between the procedural in terms of what the rules say in terms of timing and so on, and the substantive issues, which is basically in that context, who are the parties to the arbitration agreement.
Consolidation of proceedings. You have, okay, multi-contracts, fair enough, yes. Yes, so identical or strikingly similar. Yes.
And then you have center doesn't have any similar.
Yes.
Okay. In your opinion, and in the panelists' opinion, do you think if the center accepts a case that is based on multiple clauses, but the rules don't include such a regulation, so it's not really consented. So one of the parties would claim it is possible if they're identical and the contracts are related, interconnected, whatever, what have you. And then it gets at the enforcement level, it gets challenged. So do you think a court would, in your opinion, would a court allow for a multi-clause case to be decided, although one of the parties is contesting the validity of the case?
Validity of the case or the clause?
The validity of consolidation.
Okay, let me say, and then they can comment a number of points. You're talking about compatibility of arbitration clauses to the extent we're talking identical. Okay, so you have multi-contracts in a, let's say, a framework agreement and whatever, and then you have purchase orders 1, 2, and 3 or whatever, and there is an arbitration clause in each of them. You are commencing arbitration against the other party on the basis of a number of arbitration clauses.
They're not that directly connected. So,
fair enough.
Not purchase orders. Let's say an internal reconstruction of the deal to suit one of the parties. So let's say it's a hypothetical. Okay? Let's say purchase of share, and
ESCO.
The parent company wants liquidity, so so the contract would state that the price would be diverted at a percentage of, would be diverted to the mother company and 70
whatever
to the subsidiary.
Yes.
But the construction or the deal, how it's structured, the structure of the deal is loan SPA. Okay? So it's not directly, so it's interconnected, and the party is obviously intended to have one deal, one transaction, but one of the parties has the leverage or has higher negotiating power, so it's dictating the way it's structured. But it's challenging, it's challenging that it has the intention of having one transaction. and one case of it.
Let me tell you a number of things. If the intention of the parties is expressed in the contract, one way of doing it is that you have separate arbitration clauses referring to different institutions. I'll tell you, this is a situation where SIAC has suggested at one point in time that you have a cross-institutional working group to deal with these situations because it's one transaction, but multi-contracts, even though they are separate. And the immediate answer was that if the parties decided to segregate and separate the dealing, even within one transaction, by having different clauses, you go to ICC 1, LCIA 1, Cairo Center, there is no way you can then bring the other contract under the auspices of the other tribunal.
Or a strict provision in the arbitration clause of no consolidation.
Absolutely. Identical, including same institution. One of the elements that tribunals take into consideration is the identical, compatible, similar nature of the clauses as indicative of the package deal or the situation between the parties. And then this goes to the other party to showcase or provide evidence that this should not be presented to the tribunal as one deal, and that separate proceedings should have been commenced. Okay, I personally have one of the cases at the moment, specifically, where the parties had contract 1 and contract 2. They said they are standalone. You can't consolidate, that was the argument, consolidate them in one arbitration, whereas consolidation is used in relation to proceedings. So what I am simply saying, you cannot commence multi-contract arbitration in one arbitration case when you should have started separate proceedings for both. The way to resolve this is by including multi-contract provisions, as the ICC has done, as the LCIA, SIAC, HKIC, and others. The Cairo Center is amending its rules and will include a provision, and we have Dr. Dalia with us, including provisions on consolidation and multi-contracts. But to answer your question, this institution has seen cases where there were multiple contracts. I can tell you, in the media sector, in the telecom sector, and others, whereby the tribunal had to consider a number of contracts to the extent that the arbitration clause in there included Cairo Center clauses. The courts, having decided and seen those cases, in none of the situations with which I'm familiar, has the court ever set aside the award on the basis that the tribunal lacked jurisdiction in that sense, or on the basis that technically you should have commenced separate arbitration. Remember that the test before the court for setting aside or enforcement goes to jurisdiction, the existence of an arbitration agreement. It doesn't go to whether institutions should have commenced separate proceedings or not.
Even if the contracts are at least on the face of them,
they are separate, but they go to the same dealing. You may even have a situation of a contractor with an employer, a subcontractor with a contractor.
I think this is, yeah, I think this is going to be one of the cases where it will be going back and forth between appeal and cassation. But I think that cassation will prevail on accepting the concept of consolidation as a matter of Egyptian law eventually, because it has a lot of fairness and justice involved. Something we have recently seen actually, and it was quite interesting, but this was with the acceptance of the parties, is that there were two agreements, two separate arbitration clauses, but under the same contract or under the same subject matter. So we have agreed that this will be administered, both, it will be kind of two cases administered by one tribunal. They will be issuing a judgment here and a judgment there. However, we have agreed to consolidate it somehow through the arbitral tribunal itself. And this created the same concepts that we are afraid of in terms of joinder and consolidation, because we will have one judgment, non-conflicting awards, all of the facts are before the same part. However, because the arbitration clause were so different, we have only consolidated the arbitral tribunal, which was actually the creative ways of evolution.
We have, I can give you an example which we can discuss, which is a lending or facility agreement and an escrow one. And I can tell you because that's a real case. But now, yes, but now I think we have the other panel ready. So I'm informed that we need to bring this to a close. We're happy to address the questions separately with the panelists, and thank you all very much for being with us.
Yes, good afternoon. مساء الخير دكتور عمرو. احنا بس هنعمل اختبار سريع. الشهر نبيل.
ايوه انا سامع حضرتك كويس. حضرتك سامعني؟
انا سامعك ممتاز.
تمام.
نفتح برضه الكاميرات.
الكاميرا.
تمام. طيب دكتور عمرو حضرتك ممكن تتكلم بس اسمع الصوت عند حضرتك؟
حضرتك سامعني كده كويس؟
ممتاز ممتاز. معانا الشهر نبيل، ممكن حضرتك تتكلم بس نتاكد ان المايك عند حضرتك شغال والدنيا كويسه؟
مساء الخير، يا رب تكون سامعني كويس.
زي الفل يا فندم، حضرتك منور يا فندم، منور.
شكرا جزيلا شكرا جزيلا.
شكرا لحضرتك. ماشي يا فندم. احنا دلوقتي هما بس بريك 5 دقايق وهنرجع ان شاء الله على اللايف. اوكي.
تمام. شكرا.
شكرا جدا. شكرا.
شكرا.
Ladies and gentlemen, if you could please take your seats so we can begin our next session. All right, welcome back. This session is on the examination of experts and witnesses in the time of COVID-19. Our speakers include Councillor Nabil Amran, the current Deputy Chief Justice of the Egyptian Court of Cassation and the presiding judge of the court's Second Commercial Circuit. We also have, who is coming to us via Zoom, we also have coming via Zoom Dr. Amra Abbas, the partner and head of arbitration at Ma'touk Bassouni. We have as our moderator, Mr. Caesar Turneden, I hope I'm pronouncing that right, who is a partner in the International Arbitration Department at Yusuf and Partners. We have Councillor Fatma Khalifa from the Foreign Disputes Department of the Egyptian State Lawsuits Authority. And finally, Mr. Yahya Shaheen, head of arbitration at ALC Ali Din Shahi and Partners.
Thank you. It's quite a pleasure to be here today with you. Specifically with such a STEM panel, highly qualified, distinguished individuals. We've seen earlier today matters of law and then matters of the parties and joinders. We now want to get to the fun part of it, which is the actual hearing. After all, this is a huge part where arbitration comes to its, in a sense, its apex, where the parties, after having invested into making their arguments, we now come to a oral hearing, and you have your day in court to present your factual and expert witnesses. So we want to discuss today how and if any the examination of factual and expert witnesses have been affected by COVID through its virtual examination. BC, before COVID, virtual hearings were rare. It happened. They were the exception. It was odd. We did not know if a witness's eyes turning and revolving around the room amounted to a violation of due process. Après COVID, now so much practice has evolved that we have a number of institutional changes with respect to the commonality of it. And today, it's basically, it doesn't, we don't skip a heartbeat, even when we have a conference with distinguished panelists sitting miles away. So it is a new time. So without further ado, I would like to start this discussion today with a warm-up question to Dr. Amra Abbas, if I may. And it's just a warm-up, just to start. In a common law process, the factual examination, the cross-examination, as we can readily see in movies, is just a paramount. Yet sometimes we see in a civil jurisdiction arbitrations that will even forego the examination of factual witnesses. Can you tell us what the importance is of the role of the examination of witnesses and experts, and why is it so important, so that we can get to the core of how potentially virtual would affect it? But right now, can you just briefly tell us, in your experience, how is it important? Why is it important?
Thank you, Caesar. I believe the importance comes from, why do we use witness statements? Why do we use experts? We use witness statement to explain certain facts that are important, that documents might not be available, or to give context to documents, to give support to documents, to explain documents. We can also use experts for the technical knowledge, sometimes even legal knowledge for certain disputes, and that might not be available for the tribunal. So in order to look into why do we need to examine these testimonies by witnesses, factual or experts, we need to look into the direct examination, or the cross-examination. Direct examination is an opportunity to tell the story. You give the witness you've preferred or the expert and the opportunity to tell their story, to give a summary, a brief of the results they found in their own, from their own mouths to the tribunal, and also ability to comment on what the other expert, other testimonies, other submissions have commented on their witness statement. And so this is important for a direct examination. Also to correct certain errors that might have happened in the written testimony. For the cross is different. The cross importance is to show normally inaccuracies or why this this testimony or this expert opinion should not be relied upon. And generally, sometimes the cross goes to two main parts: the substance as well as the credibility of the witness or the expert. The substance can go into, first, you can confirm certain parts of your own case through this through this testimony coming from the other party, because some parts might not be the subject of this testimony, but might actually confirm your story, confirm your case, as well as give context to the testimony, show certain contradictions, show technical issues, discuss technical issues that might not be confirming with the applicable standards or rules regarding this expert opinion. So this is one part, the substance. Also, they have the credibility. There could be certain issues from the expertise of this expert. There is some kind of animosity, conflict of interest. There could be many matters that could be in cross-examination is important. It's very important to note, since many of us are civil lawyers, is that we should give certain liberty and for cross-examiner, given that there is no right to depose generally in arbitration. And this is the first time that they're able to discuss with the witness or the expert their testimony. However, the tribunal, also the tribunal might want, especially with experts, wants to understand further, as well as to sometimes confront between different experts trying to reach some kind of a result. So I think this is, in summary, what the importance of examination of witnesses and experts.
So, in a sense, what I heard is, not to ignore other due process. There are aspects of the right to present your case. There are aspects to confront your witnesses. There's an aspect that to have a full day in court. All these go to due process. Now, to keep with you, Dr. Abbas, a little bit, but just as a foreground, but to move on to Mr. Shaheen, I'd like to ask specifically then, how is a virtual hearing then affecting, if any, this important aspect of the examination of witnesses? I mean, we have such fundamental concepts here at play, at risk, that could be so readily be jeopardized. Is there a fear, a substantial fear, or not? Perhaps is there a difference in conceptually, but also perhaps we can talk about later more from an aspect of experience, but conceptually and legally speaking, how does virtual examinations differ from the in-person? And Dr. Abbas, feel free to also add anything you'd like after that, or any other of the panelists, of course. But Mr. Shaheen.
Thank you, Caesar. Well, as Dr. Amr said, the need is clear. When a party needs to support a factual point, he will revert to a witness, a fact witness. If he needs to support or to provide a strong position regarding a technical point, he will revert to an expert. So the process itself before the tribunal, it starts with the other party or maybe the tribunal asking the witness or the expert to appear in order to be examined or cross-examined in the way Dr. Amr has described. So theoretically speaking, in my humble opinion, there may not be any difference. Whether it's virtual or not, you will get the chance to cross-examine the witness, to examine the witness in chief or direct examination, and then for the tribunal to ask the question and so on. The process itself may not differ depending on it's in person or it's virtual. But I think in reality, if we take the exercise step by step and try to examine it to see the whole idea of the exercise, the intent from the exercise, and the expected outcome from the exercise, would it differ between a cross-examination virtually or not? In my humble opinion, there might be differences. There might be differences that would affect the process itself and its outcome or expected outcome based on the practice we have all seen in the past before COVID, as Cesar has said. So if we take the steps of the cross-examination, and I'll be talking about cross-examination either of fact or expert witnesses, because the differences are very minor. So basically, when you're representing a party and you want to cross-examine the expert or witness of the other party, you will need to ask him questions regarding the report he presented. He will need to present a report before he appears before the tribunal, and then call him. And during the hearing itself, you start asking him questions. The interaction you get from the exercise may help you, the reactions of the expert or the witness, the way he will be answering with confidence, with less confidence, may help you and guide you through the process. To continue with one line of questioning or maybe move to another one. And I will try to give two examples that I have had, one actually before COVID, very interestingly, and the other, it was also before COVID, but it was in person, just to give you an idea about how it was in person. For me, at least, important to have, or the presence of the witness in person helped in the process itself and helped to get to achieve the outcome, the desirable outcome from the cross-examination. My first experience with presence of a witness virtually, actually it happened in 2011, way before COVID, and it was in an investment case, one of the very first cases I've worked on. The witness, he was actually the party. He was not able to travel to attend in person. The hearing was in Paris due to some restrictions. And he needed to appear before the court, before the tribunal, to ask him some questions regarding a witness statement he provided, and for us to cross-examine him. So back then, it was quite unusual to have this kind of exercise. So the tribunal was very careful about the process itself. It started asking the witness questions about providing him with the report he has submitted, or the other party submitted, to ensure that this is his report, in order to ask him about it, if there are any clarifications or amendments he would like to introduce to it. And then the tribunal asked him a question: you are in a room, are you alone or not? And then he said, no, I have just a technical person with me to help with any problems, any technical problems regarding the internet connection and so on. I'm old, I can not handle this kind of problems. So the tribunal asked him to show the participants or the counsels present in the hearing room, the room itself where he was sitting. And then, yeah, exactly, at 360. He did that. There was a technical guy assisting him. And then we started cross-examination. And we noticed that he's looking, every time we're asking him a question, he's looking to the left upside of the room. So the third time he did that, the tribunal asked again the same question and asked him to do the 360 again, 360 again. And then there was another person wearing a suit with the appearance of a lawyer. We're not sure if he is a lawyer or not. And the tribunal asked him to get the person out of the room, and if there is any problem, we'll resume, we will make sure to give him time to reconnect and so on. But it raised some doubts about having someone in the room who may or may not be helping him, answering questions and so on. So for me, and even in an experience before COVID, the virtual aspect of the cross-examination, it lost one of its elements. To have the chance to be in direct contact with the expert, to ask him questions, a line of questioning, maybe put some pressure on him in a gentle way and within the boundaries of the exercise, but to be sure that this is his opinion, not getting any other person to help him with the exercise in any way. I felt the importance of being in the same room with the witness in another case. It was a case held actually here in Cairo, in the Cairo Regional Center, the CRCICA. And before the hearing, we were having, before the cross-examination of the witness, we were having a break. So I was smoking a cigarette, and the witness, he was smoking a cigarette as well. And this case, in this particular case, I do remember that the point in question, the very fundamental point in question, was the ability or inability of the parties to prove a certain date regarding the start of operation of a certain facility. This was the whole dispute about this date. And the fact witness they provided, the other party provided, was actually the cornerstone of their defense regarding this point. His opinion, his witness statement was very important regarding this point. So the cross-examination for us was very important. Before his examination, as I said, he was taking a break, and I noticed that he was very uncomfortable with the process, with his presence and so on, although his statement was very strong, with very strong, very detailed narrative about what happened, the timing before and after the event, and so on. And then in the cross-examination itself, he was very stable at the beginning. And then when we started hitting him with questions, very detailed questions, and comparing his witness statement with the other elements he provided in his witness statement, he started to sweat. And actually, at some point in time, he told the tribunal that I need to smoke, I need a break. And after this point, he started to answer differently. So the interaction, in my humble opinion, in this instance, and getting to see his status before the cross-examination, it helped in the process. And for me, this would be the very big difference between a cross-examination held in person or held virtually. The interaction and the instant interaction and what reactions you can get from, in order for you to, as a lawyer, to use it in your benefit, or maybe to pursue one line of questioning or another. The first example I gave maybe also raised some doubts about the communication between the expert or the witness and the other party. The tribunal will need to make sure that there are no communication. He will be looking in a screen, maybe looking at the screen, but reading something that is written to him by another party. I don't know, maybe I'm just making some assumptions, but this may raise questions about the effectiveness of the process itself. These, in my opinion, may be the differences between holding the process virtually or in person. It will be the same. It will just need the parties, the tribunal will just need to draft a protocol in order to assure and ensure that these points and any other points that any one has faced during an examination virtually may arise, just to cater for them. I can imagine a scenario where an expert, just building on the other example, an expert who is under pressure with a line of questioning that is getting to destroy or maybe take away from his witness statement, to start, I'm not hearing, to start saying I'm not hearing, or maybe to turn off his computer and say there is a electricity outbreak. But, yeah, the imagination is wild, and maybe we can face these scenarios in person. So it may take from the process, but I believe with some guarantees, with some organization in advance, the experience could be the same.
Thank you, Mr. Shaheen. I think you got to my next question, actually. I think that it's true that no one can say that it's the same. There are differences. Certainly, I've made witnesses cry on the stand, sometimes in my benefit, sometimes sometimes my own witness for my benefit, sometimes the other witness for their detriment. And clearly that happened in a court of law can have an impact where I don't know, and I don't believe you would, that it would be the same when the person is in the same room. But knowing that there are granting that there probably are differences, then what is it that advocates can do specifically, and also arbitrators, to address these differences, not only to guarantee due process aspects such as the integrity of the testimony, but also the ability of a party to actually properly handle the cross-examination in its fullest by observing the sweatiness, the nervousness, and so on. So I would, Mr. Abbas, if I can just, Dr. Abbas, if I can go back to you and if I could ask you, in your experience, what do you think that we, our audience, arbitrators as well, need to do to make sure that given differences, we just evolve as better practitioners and developed this perhaps a new set of skills that are completely different from what we learn in law school, very different from what we practiced before COVID. What can advocates and arbitrators do to overcome these issues and guarantee the integrity of arbitration hearings, please?
Thank you for the question. I will start with the last point that Mr. Shaheen was making, is having this kind of protocol where the tribunal should set in consultation with the parties of how this should be very much from the beginning. How would we deal with this examination remotely? Things like what platform we are going to use, electronic bundles. The issue that Mr. Shaheen was focusing, and rightly so, the issue of witness coaching during the testimony. What kind of technology do we need to make sure that this doesn't happen? Camera 360, several cameras, maybe one representative from the cross-examiner of the other party will be sitting with the witness during the testimony. Maybe the witness will, we could agree on perhaps, and all of these examples I have seen recently, and some of them actually pre-COVID, we have seen cases like Mr. Shaheen, that certain one expert or one witness was not able to come for whatever reason, and we had to examine the witness remotely. So issues like this, what procedures to take if there is interruption, if like Mr. Shaheen was saying, the electricity went off. If we prepare for this from the beginning, especially the tribunal might make sure that certain things are ready. You have more than one internet connection ready. You have made several tests before between the tribunal, between the and the witness and the other parties, speaking techniques, who should start with and how we end, virtual sequestration, how would during breaks, if the witness is going to have to speak for or examined for more than an hour or 2 or 3, there will be for sure some breaks. And what will happen during breaks? How would we cover this? There are many technological answers, I would say, as well as other answers that the tribunal, in consultation with the advocates, may be able to reach and solve all the concerns that we may have. The whole idea of the demeanor and the body language of the witness that would be very important, and also Mr. Shaheen spoke about. I think this could also be solved through technological manners, through different kinds of cameras that could actually observe this even sometimes better. I had a physical hearing recently where witnesses were actually wearing masks. It might be even better, and everyone is wearing masks. And probably if I have the witness sitting without wearing a mask and with cameras and technology that is good and connection that is good, I think this is even better for the tribunal to observe the demeanor and the body language of the witness, and issues like interpreter and the location of the interpreter as well. All of these issues should be sorted out and trying it. We had recently a case where there was an issue with interpretation and the interpreter connection, and whether, so these issues, if we are from the beginning having several tests ready for that, this would solve many problems. So what I would say is that tribunal with the parties, with the advocates, should agree on this, and the tribunal would be able generally through these, going through certain lists. There will always be issues for sure, but I think they are all can be solved, and easily now with the technology and the speed of the internet that we can actually solve this. For the advocates, I would say the advocates will have to also be ready for this kind of examination. They have to prepare their witnesses to be able to use the technology, to be comfortable looking to the camera, to try with them how this will happen, as well as also to be ready with, for instance, clean copy of all the exhibits that will be needed, or the whole case record, whatever things that they may be able to help through, in consultation with the other party, how the witness will be helped, and how would they show them either electronically and direct them through evidence, or even if there is anything happens, there could be a clean copy ready, and this again could be checked with either by camera, by looking somehow into the copies and make sure that they are clean, or there would be a representative from the other party, especially for the key witnesses and the key experts. I think these efforts will be expenses that well spent. I think this is generally from advocates' side and from tribunal side. I think this would solve many issues if this happens. And we have probably can speak about experiences that we have, recent experiences doing this during this session or after.
Thank you, Dr. Abbas. Perhaps we should take a little bit of a break here in this thought, and I just put this aside, and then we should try to step out and see how video conferencing has been looked at in other international, through the lens of other countries and other arbitration institutions. So if I may, Honorable Nabil Omran, will you, how have, if I may address you, how have countries and arbitral institutions addressed the emergence of video conferencing?
Thank you, Mr. Turndine. First of all, I would like to thank the Alexandria University and the Center for organizing such an event. And I'm also glad to be part of this distinguished panel. Would you like me to answer the question or to start my presentation?
That was my cue for your presentation, please.
Okay. Let me start from the beginning. I'll speak about some of the salient aspects of virtual hearings. My first observation is that the use of video conferencing in arbitration hearings is not a novelty. Before COVID-19 pandemic, virtual witness testimonies were applied in specific cases, such as when witnesses could not travel and reach the venue because of illness or because of visa problems or any other reason. And the rules of arbitration of CRCICA in Article 28.4 states that this is in 2011, says that the tribunal may direct the witnesses, including expert witnesses, be examined through means of telecommunication that do not require their physical presence at the hearing, such as video conference. Also, the Article 8.1 of the IBA rules amended in 2020, but I'll leave this point to my colleague, Councillor Fatma Khalifa. She's gonna give us some details about the IBA rules. Also, before the COVID-19 pandemic, in November 18, the Seoul Protocol on video conferencing in international arbitration was first introduced in Seoul ADR Festival as an initiative in response to the advent of video conferencing in arbitration. But after the COVID-19 pandemic, countries and arbitral institutions are addressing the emergence of video conferencing in their legislations and rules. The amendments to arbitration legislations in recent years by states such as the Netherlands, Austria, and Hong Kong allow witness examination to be conducted without physical and personal appearance of the witness at the hearing. Arbitral institutions have similarly amended their rules so the video conferencing can be accommodated. The uncertainty of when we may return to normal life has forced the parties to adapt to new facts of life by relying entirely on virtual hearings, including virtual witness testimonies. There has been many personal initiatives in that sense. Professor Muhammad Abdul Wahab has published in 2020 a 6-point pathway. It is called and well known as Abdul Wahab's pathway that may be followed by arbitral tribunals when dealing with this issue. This pathway has been very much welcomed and appreciated by the arbitration community. Several arbitral institutions issued guidelines and hearing protocols such as, for example, the Africa Arbitration Academy Protocol on Virtual Hearings, the ICC Guidance Note on Possible Measures aimed at mitigating the effects of COVID-19 pandemic, the Vienna International Arbitration Center, VIAC Protocol, the ICSID Guide to Online Hearings, the LCA Guidance, the Hong Kong International Arbitration Center Guidelines. These efforts have made the continuance of arbitration proceedings possible despite the challenges caused by the pandemic. However, these benefits were not without problems. A recent decision by the Austrian Supreme Court, rendered on the 23rd of July 2020, is a good example of these difficulties. The Supreme Court rendered a decision examining whether conducting an arbitration hearing by a video conference over the objection of a party may violate due process. This decision, rendered in the context of the COVID-19 pandemic, is the first national Supreme Court's decision worldwide addressing this issue. And at our court, we are interested in following what's going on in the world and what's new in the arbitration judgments specifically. The respondents in the arbitration seated in Vienna and administered by the Vienna International Arbitral Center had challenged the arbitral tribunal over its decision to conduct an evidentiary hearing remotely by video conference. After the VIAC had rejected the challenge, the case went to the Supreme Court. The respondents complained about the remote nature of the hearing and the early start. They also claimed that they were not given appropriate notice of and could not adequately prepare for the hearing because the tribunal's decision not to postpone the date was issued only 3 business days before the hearing. In addition, they argued that the tribunal's decision to start the hearing at 3 p.m. Vienna time, which is the time zone for the claimants, and 6 a.m. Los Angeles time, which is the time zone for the respondents' counsel and witness, amounted to an unequal treatment of the parties. Lastly, the respondents argued that holding a remote hearing amounted to a violation of the tribunal's duty to treat parties fairly because the tribunal did not put measures in place to prevent witness tampering. And the Supreme Court answered for the 3 arguments. On the tribunal's decision not to postpone the hearing and to conduct it remotely, the court ruled that in the circumstances of the case, the tribunal's decision to conduct the hearing remotely at the scheduled date did not amount to a breach of the tribunal's duty to treat the parties fairly. Parties must consider that the tribunal may not grant a request for rescheduling a set hearing date, which had been known for both parties for months. The court emphasized that the Austrian legislature has expressly promoted the use of the video conferencing technology during the COVID-19 pandemic to ensure that judicial proceedings could be advanced. Importantly, the court confirmed that, as a general rule, remote arbitration hearings are not only permissible if both parties agree, but also over the objection of one of the parties. On the second issue of different time zones, the court held that by concluding an arbitration agreement providing for VIAC arbitration and an institution based in Vienna, the respondents had in principle accepted the disadvantages resulting from the geographical distance to their place of business, including substantial travel and time differences. In addition, the court took the view that starting a hearing at 6 a.m. local time was less burdensome than having to travel from LA to Vienna for an in-person hearing. Lastly, on the fear of witness tampering, and this relates to what Dr. Abbas was explaining. The court found that the risk of witness tampering also existed in in-person hearings through influencing witness testimony prior to the hearing or feeding the witness information on other evidence adduced during the course of the hearing. The court added that remote hearings allow for measures to control witness tampering. Such measures specific to remote witness testimony include the technical ability of all participants to observe the person to be examined closely and from the front, the possibility to record the evidence, the option to instruct the witness to look directly into the camera and keeping his or her hands visible on screen all times, making it impossible to read any chat messages, and finally, showing the room in which he or she is testifying, ensuring that no other person is present. Such a landmark decision is worth a long analysis that we don't have time for it right now. But to conclude, I think it is expected that there will be a wave of challenges to arbitral awards globally for reasons relating to virtual hearings and due process, raising issues similar to those with which the Austrian Supreme Court was seized. And as you may have noticed, virtual hearings are here to stay. So we are likely to see further regulation of virtual hearings in the national laws of various jurisdictions and the arbitration rules of international institutions. In turn, state courts around the world, also in Egypt, will have to strike a fine balance between the due process guarantees and the implications of their decisions on what might become the future of the arbitration hearings. Thank you for your attention.
Thank you, Honorable Nabil. It reminds us how the original agreement between the parties to refer to specific set of rules can be a very important aspect that gives a wide range of power to the arbitral tribunal to make decisions with the specific logistics of hearings, and therefore it is in the best position to make decisions with respect to these on the spot conducting their own hearing. Thank you very much. Given this background now, then perhaps we can take a look more on our experience, and then if I can turn our attention to Councillor Khalifa, how has it been your experience in addressing rules that bind or that expand in handling issues related to virtual examinations in your practice? And the question will also be to Dr. Abbas. So you're both on the spot.
Thank you. Okay, first I would like to thank the organizers for their invitation. It's a privilege to be in this distinguished panel. I realize that most that should be said has already been said by my colleagues, so I will try not to repeat certain ideas. But if we can just move a little bit back to the question of whether a virtual hearing is permissible or not in the first place, because we tend to go into the details of the topic without first addressing the question, is there a right for an in-person hearing? Because this is not a clear-cut question. There is no clear-cut answer to this question. It depends on many factors. Necessarily, it will you will need to look at a variety of rules and laws. First of all, of course, it's as arbitration is oriented on the idea of party autonomy, then we need to revert to the arbitration agreement to see how the parties reflect this, because if the parties are already in agreement that a virtual hearing is permissible, then there is no much trouble. But then we need to also look at the rules applicable. If we are in an institutional arbitration, then how clear are the rules addressing this issue? Because as has already been said, most of the rules, when they were written, the institutional rules, it was pre-COVID time. So at that time, it was an option, but the COVID reality made this virtual hearing at a different magnitude. Another layer is, and we should never put it aside, is the rules of the seat of the arbitration, because at the end, the law, I mean, of the seat of arbitration, because if you're operating in a seat which perceives that hearings should be held in person and that the parties have a right to an in-person hearing, then of course you need to bear that in mind, since the arbitration practice is based on a backward approach, meaning that at the very beginning of the arbitration, you need to be thinking about the enforcement of the award at the end. So any troubles that can taint the process, you need to deal with it at the beginning to make sure that this is covered and not a problem. And finally, sometimes rules are very specific to our question, and this leads me to the International Bar Association rules on the taking of evidence. Such rules has been amended, as has been mentioned by Honorable Judge Omran in 2020. And one of the salient features of the amendments is that of Article 8.2, where it was expressly stated that although witnesses' appearance shall be in person, however, this is under the caveat that the arbitral tribunal has, after consultation of the parties, decided that the hearing should be conducted wholly or partly as a remote hearing. So if the IBA rules 2020 version is inserted in the parties' agreement, then this is an express agreement by the parties that allows for such practice. Also, reference has been made to the remote hearing protocol, which has been mentioned by my colleagues, which sets all the issues that could arise and make sure that the process is done in a smooth way to ensure that factors of efficiency and cost implications are avoided and so forth, but at the same time without jeopardizing the due process, the fairness between the parties, as well as the opportunities of the parties to be heard. And in Article 8.2 of the same rules, also to address the issues that has been mentioned by my colleagues, that there needs to be measures to ensure that witnesses giving oral testimony are not improperly influenced or distracted. And this is very important, because I agree that there could be a similarity between the cross-examining a witness in person or virtually. However, due to the delicacy of the matter, it remains that in general, a human touch, a human presence would be more favorable to the process, unless there are other factors that mitigate for a virtual hearing. So there always should be weighing of the different factors at hand. And finally, there also the IBA rules mentioned the issues of cybersecurity, and it introduced the idea and defined it as a threat to the efficiency of the process. In terms of, if we look at a broader approach about virtual hearings, and in my experience, we have done a lot of virtual hearings in different at certain stages of the arbitration proceedings, if you can say. We rely extensively and I'm talking about the Egyptian State Lawsuits Authority, the arbitrations that we handle, that the procedural hearings at the beginning, there is no need that these hearings be done in person. And we have been with certain institutions that it was, and I'm talking about 2011, when the height of cases were filed against Egypt at the same time. And the arbitral tribunal was trying to say, okay, you do it virtually, the other party would do it in person. And then we, of course, objected to this, as there has always to be equality of treatment between the parties, and it's also important to maintain that this is your right as a counsel to have the same privileges or the same conduct of the proceedings. Another hearings or phase of the proceedings is the hearing on bifurcation, for example, which is the bifurcation of the proceedings between jurisdiction and merits. This is also a very procedural issue that could be handled in a virtual mode. Of course, to the extent possible, and I'm talking on my own personal view, if we're talking about the main hearing with the merits, and there remains to be the best way is to be in person, really, because either regarding the pleading of the counsels or the witnesses, then to the extent possible, if we are back to normal, then normal is being in person. But since now the normal is specified about the time you're talking about, and I think now we have no option but to deal with the normal now as being a virtual one. So as far as possible, it's very important to make sure that there are guidelines that make sure that all the aspects of efficiency is preserved, but not at the expense of due process. And I think I can conclude here about this.
Thank you, Counselor. Dr. Abbas, if I may ask you to also address this question. However, I will ask you to be as succinct as we can, as I would like to meet our deadline, and we have one set of final concluding remarks. So if you would please share with us how has it worked out for you?
Certainly. I had several experiences with this, some as advocate, some as an arbitrator, and some as actually being the expert witness being examined. And they all, I think, went well. One exception we had was with an interpreter. So generally in different rules, PCA, investment arbitration, exit arbitration, we had experience where we had the expert going to the Cairo Regional Center here, although it was an exit arbitration, and we had everything. The experts were there. We had a person from the cross-examiner attending with the expert, and the interpreter was sitting somewhere else with the tribunal. This was generally fine. The only issue was interpretation. We had at this. We had also a case where I was examined, and again, just having everything ready, having clean copy of all the documents, having the internet and have different networks ready, having tests before and doing this. One observation I would say that sometimes, and this happened even before COVID with me, in a CRCICA arbitration in 2017, if I'm not mistaken, and the expert was not able to, was from the UK and was not able to come to catch a flight for whatever reason, and we had him on Zoom or Skype. And actually the expert, I was a cross-examiner, and the expert was very relaxed to the extent we were able to get even more and better information, I think, than sometimes when an expert or witness are very nervous, to the extent that they might not actually help the tribunal and help the examiner to get to discuss the matters in a better way. We had also cases where the chairperson was the only one physically exist, and the other arbitrators were coming from, were actually were participating virtually, and this also went well. Some interruptions happened, but again, especially this was in the beginning of the COVID last year in ICC arbitration. But generally, as long as you plan it well, it went very well for us. I don't think there was an issue. As long as this was tested before and we had our precautions and we made sure that whatever the witness or expert either have someone with them or making sure that the cameras were there to avoid any kind of poaching. And we had several examinations and this went very well. I hope I was brief enough.
Thank you, Dr. Abbas. And in fact, I can certify that you are not a cat right now. I think that that does come to the real point that we must prepare ourselves in thinking ahead of all that's going to happen as advocates and also as arbitrators, because it's your job to make to guarantee the process, but as advocates as well to think about all the ticks that what can go wrong, and to train yourself, train your team, prepare, be ready, and be attentive, because the other side may not be as attentive, and it's your job to protect your clients. So in my final question then, and this of course is open to everyone, but I would like to address this particularly to Councillor Khalifa and Mr. Shaheen. So is this it? Is virtual arbitration the future? Is virtual examination the future of arbitration, or is this just a period? I have heard today conflicting feelings, and I would like to hear from you. Is this to stay? Is this a period? Will we change fundamentally as practice advocates into a new form of practice, or we're just learning a new set of skills that may become useful in the future, but not? What are your impressions?
If I just may very briefly, cross-examination virtually existed before Corona and will exist after Corona. Hopefully Corona will be, we'll see the end of it very soon, inshallah, but they will exist. My question, or maybe what I want to add to your question, Caesar, is that would it be the general rule or just the exception? Maybe in our collective experience, we have faced good situations or bad situations with takeouts in order to improve the process itself and so on. But in my opinion, and if I have that choice, I would definitely prefer to have the cross-examination in person after Corona. If it's not possible, the practice we had during Corona would definitely help to improve cross-examination virtually in the future.
Well, I share your view about this, and I think I just need to stress that this matter needs to be dealt with on a case-by-case basis. There is no one-size-fits-all for all arbitration, so we need to allocate this technique of virtual hearings when it could work best, and to avoid it when and to resort to the traditional way, if you can say, of arbitrations when we don't. And I would just like to stress also on the fact of the success of the virtual hearings in general depends on two issues. First is the trust between the parties, because if there is trust between the parties, then this can move forward better. And this is linked to the second point, which is the expertise of the parties, because if the parties have the necessary expertise, then they would know what should and should not be done to the witness, and the fact that he or she should be expressing their views and should be on their own, and no interference or distraction should be made. So I think there are more questions regarding this issue than answers at the point, and I leave it here. Thank you.
Thank you, Councillors Khalifa and Mr. Shaheen. If Honorable Nabil or Dr. Abbas have any final comments or ideas on this, may you
Yes,
speak.
I would like to conclude after the comments we've heard. We are under a necessity right now. And as we all know, the necessity is the mother of invention. I think virtual hearings are here to stay even after COVID-19, because there is a new fact. People are going to use virtual hearing, as I believe, even after COVID-19, even after there is no travel restrictions, because maybe they were afraid of using it before. Now everybody is happy to work from home instead of going to work. He learned a new lessons in COVID, made us taught us new lessons, and therefore I expect that virtual hearings are going to gain a big portion in the future of the arbitrations, not necessarily with the disadvantages of cross-examining the witness, maybe especially in the arbitrations or small arbitrations that both parties need no experts or witnesses. This is the most the comment I would like to conclude with. Thank you.
I certainly agree with Judge Omran. I believe we all had a taste of the efficiency that is being created by this means and the way it can save time and expense. And so in many circumstances, even after COVID, I believe there would be more use of remote hearings, and perhaps it will depend again on a case-by-case basis, but I think people and people have already tasted this, and they would like to continue, at least in certain cases, to gain the advantages of efficiency and expense saving and others for by having virtual or remote hearings. Thank you.
Thank you both. Running the risk of being late, I would like to open the floor for two questions, if there are any. Otherwise, I would love to cede the floor for the next panel. Are there any questions that perhaps cannot be asked outside individually to the panelists? Yes, please.
Threshold for arbitral tribunals, or maybe the more strict obligation to foresee attempts by parties to evade virtual hearing or to evade the hearings in person for fear of exposing their clients or witnesses or expert opinions. How could the tribunal foresee that, and given the circumstances of the case and given the importance of the dispute, they make such a decision regardless of the party's information?
Well, if I may, I think that the tribunal needs to be to again strike the balance between the required efficiency of the proceedings and the threats of one of the parties using due process violations as a threat to the award when it's issued. So there is no answer to this, rather than the tribunal should use their discretion wisely and precaution their decisions for the examination of witnesses to that effect. But parties will all the time try to manipulate or abuse the right, and the tribunal would have to be firm about it that the proceeding need to be to continue efficiently.
Thank you. I would add perhaps that one cannot or should not presume that that will happen because it's a presumption of bad faith in performance of an agreement to arbitrate. But the arbitral tribunal's job is to make sure that there's no room for abuses. And then to that extent, I think that the arbitral tribunal is empowered, at least certainly under all institutional rules that we know, to effectively enforce and conduct the hearings in a manner that guarantees both sides, not necessarily through the absence of waivers, but certainly to affirmatively guarantee equality. So you have more checks and balances on that. So then with respect to the remainder, I would agree with everything that Councillor Khalifa has indicated. In fact, I have to apologize because I was corrected. We did not have the right to 2 questions. We had the right to only 1 question. So we are now being evicted from this place, and I do certify that we're all not cats. Thank you very much. I appreciate your time and attention and the comments here today. Thank you so much.
Thank you.
We have a quick 10-minute break until 6:45. And then we will start again with the next session.
مساء الخير دكتور يحيى، ازي حضرتك؟ احنا بس هنعمل تيست صوت سريع، عاوز اسمع صوت حضرتك.
مفيش مشكلة يا فندم، حضرتك سامعني كده بوضوح؟
زي الفل يا فندم، اتمنى لك التوفيق ان شاء الله.
متشكر جدا يا فندم. معلش ما اتعرفتش اسم حضرتك؟
انا يحيى رشواني يا فندم.
استاذ يحيى؟
ايوه، مركز القاهرة.
اهلا وسهلا.
اهلا بيك. طيب حضرتك عندك برزنتيشن او حاجة؟
عندي برزنتيشن باوربوينت
طب نجرب نعرضها ونشوف بس تيست بسرعة مع بعض.
أوي أوي أوي.
اتفضل.
كده تمام؟ واضحة؟
زي الفل يا فندم، زي الفل. زي الفل. نشكر حضرتك جدا ونتمنى لك التوفيق.
شكرا.
ممكن نقفل بقى الباوربوينت لحد ما
مفيش أي مشكلة.
دكتور شريف لحد ما زي الفل، اشكر حضرتك جدا. شكرا.
Ladies and gentlemen, we'll now begin our final panel with as a moderator, Mr. Yusuf Saman, partner at the International Arbitration Department at Zulfikar and Partners, Ms. Counselor Aula Nagy from the Egyptian State Lawsuits Authority, Mr. Ibrahim Shaheta, partner at Shaheta and Partners, and Mr. Mohammed Saimi, senior associate at Matoub Basuni.
Thank you very much. First of all, I'm very happy to be with you here. It's the first event to attend physically since almost 1 year. But the pleasure I find in being with you here, I admit, defeats my concerns about COVID-19. So I'd like to first introduce my esteemed co-panelists, and I'll go in alphabetical order. To my far right, Mr. Ibrahim Shaheta, and Ibrahim has experience in the Egyptian market for about 10 years. He started with reputable law firms, and then he moved to the US to get his Master of Laws in International Arbitration, New York University. He has also a corporate side. So he worked on corporate law, on transactions with multinational companies, and particularly in the renewable energy market. And he has a focus on arbitration, and he has prosecuted and assisted clients on various arbitration cases under several rules. And he also has some publications on different aspects of international arbitration. To my left is Mr. Mohammed Sami, and he's a senior associate with Matoub Basuni and Hanawi in the arbitration team since 2015. He has more than 5 years experience in international arbitration, and he handles international commercial and investment arbitration cases under various rules, including ICC, ICSID, CRCICA, INCITRAL, in different industries, including oil and gas, M&As, construction, and other industries. Mohammed had his LLB from Cairo University, English section, and he obtained his LLM also from Cairo University in 2017, and he has an LLM from University of Cambridge in 2019. And that's focusing on international investment law. And to my near right, Ms. Aula Nagy, and Aula is a state counsel in the Foreign Disputes Department of the Egyptian State Lawsuits Authority. Ola has about 6 years experience in international arbitration, and she has worked with reputable firms in Egypt. She also assists in coordinating the regional and international rounds of Monroe E. Price Media Law Moot Court Competition, University of Oxford. And congratulations, recently in 2020, she obtained her LLM in international dispute resolution from Queen Mary University of London, UK. So, not much to say about myself. I'd like to move forward to our discussion. And as you have noticed, the topic is one dispute, three laws. And this time we cannot go in alphabetical order because we have a lady on the panel. So we need to start with her. So a belated Happy International Women's Day to her and to all the ladies in the room. So Ola's going to address the three main laws that may apply in the context of arbitration. And I'm very careful choosing in the context of arbitration because laws do not necessarily apply to an arbitration. We have some laws that may apply post the arbitration. And I think Ibrahim is going to address that post-arbitration phase. But generally speaking, the main laws that you can start with in the context of an arbitration are the law applicable to the substance, the merits, and I appreciate that arbitration backgrounds may differ among the audience. So that's basically the law that applies to the substance, the issues in dispute as in merits of the case. The second law would be the law applicable to the procedure or to the proceedings, and this governs the conduct of the arbitration itself, and eventually the law that applies to the arbitration agreement, or in other words, to the jurisdiction. This is the law that answers the question whether the tribunal has jurisdiction to address a certain issue. So I leave the floor to Ola, please.
Thank you, Yusuf. At the outset, I'd like to start by giving thanks to Alexandria University and in collaboration with CRCICA for inviting me here today to be part of their second conference regarding their previous moot competition. Honestly, I feel like being in home today among my very dear friends and colleagues from CRCICA, from previous law firms where I worked, like including Zulfikar and Shahid law firm, and also friends from that I was lucky enough to get across, knowing them across mooting. As you may know, we have a different types of mooting. I assist in the as Yusuf previously said, I assist in the Price Media Law Moot Court competition since 2014. So it's a great pleasure for me to be here today. Also to be with among my favorite audience, who's are the students whom I get the chance to interact and deal with during mooting. And before I indulge into the topic, I'm wholeheartedly proud of each one of you who tries to get out of their own ways and their comfort zone from just studying their regular curriculum and at law school, and they try to seek experience and to open their horizons into a wide range of knowledge through doing competitions like this one we're here today because of. Also, I truly believe that mooting is an experience that provides students with a huge professional and interpersonal skills like legal research, legal analysis, and critical thinking, the teamwork, and also public speaking, which and most importantly, the wide range of knowledge they deal with while they work on their cases, regardless of the topic of the mooting. As we have the VIS deals with the international commercial arbitration, we have the JESIP, which concerns the public international law, and moreover, we have the Price Media, which concerns the media law and human rights. So today, I'm very grateful for being here with you, doing something that I truly enjoy and love while speaking about arbitration, and to an audience of great mooters like yourselves. So before my time is up, expressing how happy I am for being here today, let me shed some light briefly on a number of systems of law that may simultaneously apply in the context of international arbitration, which are different from one another. Firstly, we have the Lex Kozai, which is the law applicable to the substantive issues between the parties. It's generally chosen by the parties. However, absent such agreement between the parties as to the applicable law on the merits or how it's to be determined, there are two possible, or there are scenarios where the arbitral tribunal has broad powers to rule on the substantive law. There are countries like France and Switzerland where their international their laws applicable to international commercial arbitration has provisions indicates or stipulates that the tribunal free to decide on the issue of the substantive law. On another scenario, and also to consider what the appropriate laws to settle the dispute. In another scenario, in many other countries, however, there are countries they don't have such a liberal arbitration regime, and the tribunal is required to resort to the rules of the conflict of laws in order to settle to choose the applicable law or the substantive law on the merits. Secondly, we have the lex arbitrae or the lex arbitri, which refers to the procedural rules that govern how an arbitration unfolds. These rules can be located in institutional rules for parties who opt to arbitrate under the auspices of certain international institutional arbitration, such as CRCICA, the ICC, the EXID, the LCIA, etc. Or enshrined under the UNCITRAL rules for the parties who opt to arbitrate, opt for a non-institutional arbitration. In principle, this law may be that of a different state than the law governing either the arbitration agreement or the underlying contract. Thirdly, we have the law of the seat of arbitration. It's not the same as the location where the hearings are conducted, which is the venue of arbitration. It's the domicile of the seat of the arbitration. It's the domicile of the arbitration, and as such, it's a legal construct rather than a geographical location. In practice, there are a variety of mechanisms for choosing the arbitral seat. In the vast majority of cases, the arbitration agreement will specify the seat of the arbitration. However, if the parties have not agreed on the seat of the arbitration, it will be chosen by the arbitral institutions or the tribunal. In rare instances, will national courts play a role in selecting the arbitral seat in international arbitration? I shall now leave the floor to Yusuf and my colleague.
Thank you very much, Hala, for your insights. And I would like to add that given the matrix, or as it's commonly known as a layer cake or regulatory web of laws that may apply in the context of international arbitration, the sources and this difficulty is in fact compounded by the fact that for each of these issues or these laws, there is possibly a diversity of sources of norms. This includes necessarily treaties, institutional rules, national laws, soft laws as well. So it's really, it can get really intricate, and there were scholarly views, different and fundamental disagreements that led to the traditional and modern theories of international arbitration. I would go now to Ibrahim to address a few beyond the three main laws that may apply in the context of international arbitration. Ibrahim.
Thank you, Yusuf. Hi everyone. I'm really happy to be here today. So as like my colleagues were saying, there are three principal laws, or maybe usually two, that that are being discussed in every arbitration: the lex arbitri and the law applicable to the merits, and sometimes nowadays the law applicable to the arbitration agreement also becomes a place for discussion. But there are other laws, and especially if the arbitration is like so diverse and has so many different pieces everywhere. So for example, you can have some of the laws, for example, that apply to arbitration and have specific conflict of law rules is, for example, the law applicable to the capacity of the parties. So if you go to the New York Convention, they say usually that it is the law of the nationality of that party. Other laws, for example, the law applicable to the arbitrability, and that has been subject to a huge discussion. And if you, and I think there is a great paper by Professor Stravos from Queen Mary about whether it should be the Lex Fori or should be the law of the seat, and whether it should be detached from public policy or not. Another issue that is different, and something that cannot be agreed in the arbitration agreement, for example, is that the law applicable to attorney-client privilege. It's something that happens even before the arbitration agreement is written or is drafted. And it is there are very many different scenarios where you can see they apply the most protective law, they apply like mishmash, like, standard that, goes between civil law and common law jurisdictions. So there are different laws that apply. I remember fondly when I went to the US, the first thing that I was discussing with my professor, he told me to write about the law applicable to confidentiality in arbitration. I thought that was very, very specific. And there were only 2 pages in Gary Bourne's book about that issue. So there are different rules. And if you go to Gary Bourne's book, you will find like at least 10 different laws applicable in arbitration, like formal validity, substantive validity of arbitration agreement, subjective arbitrability, objective arbitrability. There are a lot of things. So that's the core that I would like to note about that. Thank you.
Thank you very much, Ibrahim. And just a couple of points on what Ibrahim has addressed. The issue of privilege, or what law applies to confidentiality in arbitration, is indeed an interesting one. And the problem arises where some laws do include some norms for confidentiality, while some parties sometimes struggle to include other standards or higher standards of confidentiality and privilege in the arbitration. Another one point on that Ola has touched upon, which is the AlexU-CRCICA, or the law, the seat, where the parties do not agree on a seat in their arbitration agreement. There are different approaches, but generally most institutions would include a default seat if the parties have not agreed, such as like, for example, the Cairo Regional Center. If the seat is not mentioned in the arbitration agreement, then it's considered Cairo, unless the party. I move now to Mohammed, and Mohammed is going to address some aspects in relation to the exclusion of the applicable law, which is indeed a very argumentative topic in almost in all nullity cases. It is being raised that the tribunal has excluded the applicable law. So what is it particularly, the exclusion of applicable law? How does it apply? Mohammed is going to address that in more details. Mohammed.
Thank you, Yusuf. And thank you very much to CRCICA and Alexandria University for having me here today. So having spoken about applicable laws, on different applicable laws on arbitration, now time to speak about what is the effect or what is the consequence of breaching those applicable laws. So it's interesting actually, because this seems to be peculiar to Egyptian law, because this provision 53D almost doesn't exist in any other arbitration law except actually Egyptian law, although it can be applicable also in other legal systems under different names, like, for example, ICSID. When they say excess of power, this may be construed as an excess of power. So the article says exclusion of the applicable law on the dispute. So first of all, the first thing is that it must be the applicable law on the dispute, which means the substantive law applicable on the merit, which is maybe or may seem weird, because if the parties' agreement on an applicable law on the merit is sacred to the extent that Egyptian law provides for nullity in case of exclusion of it, one should say that the law applicable on arbitration agreement itself, which is related to the power and the authorities of the arbitral tribunal, if the parties agree on it, it should be, or some may say it should be, more sacred and more protectable than the law applicable on the merits. But anyways, this is what Egyptian law says. So when this article is interpreted, it says that there must be 2 conditions. The first, apparently, is that the law must be the applicable law on the merits. And the second is that the parties must have agreed on this applicable law, not only that the law, for example, is the most closely connected to the dispute or something like that. There must be an agreement, because it's only in that case that exclusion of that law would be a deviation or an excess of power by the arbitral tribunal, which was conferred to it by the parties, expressly by the parties. So these are the conditions, the general conditions, before we enter into the most important one, which is the word exclusion. Of course, this has been subject, as Yusuf said, to so many appeals before the Court of Appeal, and some of them also before the Court of Cassation. When we can take, for example, some interpretations, the courts are established, or it can be said they are established, that if a parties agreed, for example, on a national law, and the tribunal applied the law on a different branch. So, for example, if the parties agreed on civil law and the tribunal applied commercial law, this should not be considered as an exclusion of the applicable law, because after all, the law chosen by the parties was applied. But this is not the case if the parties, for example, say the tribunal shall apply the Egyptian, for example, the Egyptian commercial law, and the tribunal applies the civil law. So this would be considered as an exclusion of the law applicable or decided by the parties. Also, there was an interesting part which was raised in multiple times. So we had the famous rule, for example, contract makes the law of the parties. So if the tribunal doesn't apply the contract correctly, or if the tribunal completely excludes a provision in the contract, does this provide for an exclusion of the applicable law chosen by the parties? So, for example, if the parties say that the tribunal should apply the provisions of the contract, it seems bizarre a little bit, but the Court of Appeal in Egypt had ruled that but it was a bit old, has ruled that this case might constitute a reason or a ground for nullity. Then comes the point which for me is the most interesting in this part, which is the gross error of law or the distortion of law, because it's known or it's established under Egyptian courts rulings that an error of law, a normal error of law, is not considered as an exclusion of the applicable law, because after all, a nullity lawsuit is not an appeal to an arbitration award. So, however, in a report by the legislative committee in the drafting stage of this law, they said that a distortion or a deformation of the applicable law is considered as an exclusion of the applicable law. Of course, this raises a number of issues, and many criticized this addition or this this explanation, because after all, this is considered as travaux préparatoires, and therefore they should not, or according to this opinion, they should not have authority or presiding over the text of the provision itself, because the text says exclusion. However, on the other hand, one can think of some cases where a distortion of law is just equal to an exclusion of law. For example, when you speak about an award that says, for example, we will not apply interest rates because it's against Sharia, so we apply Sharia, so we will not apply interest rate. And this is actually a real case where the Court of Appeal stated that the award is null because it excluded the applicable law. What is the difference between this case and another case where the court simply states that I apply Egyptian law, but I will not rule on interest rates, which is totally against Egyptian law? Another example, what if a court or an arbitral tribunal states that I apply Egyptian law, for example, Article 221 of the Civil Code regarding compensation, and awards, for example, punitive damages, which is totally against or foreign to Egyptian law. So in those cases and other cases, one can say that a distortion of the applicable law, even if not expressly stated, is considered as an exclusion of Egyptian law or any other applicable law. However, this of course leaves a great room of ambiguity, because when one thinks about gross error in law or distortion law, how can we define such a term? I think, in my opinion, it cannot be defined without mentioning terms which are equally ambiguous. So if you can say, for example, gross error of law or distortion of law, we can say, for example, that it is something that goes completely against law. So what goes completely against the law? it's equally ambiguous. And for me, this is one of the main disadvantage, we can call it, or main defects or deficiencies of law in general, not only arbitration, but also for me, they are also one of the most interesting parts of law, because this is where lawyers should work actually. So for me, this was subject to difference in jurisprudence and difference in courts, and there were so many cases before Cairo Court of Appeal, and still until now there's no single criterion to differentiate between a distortion of law and an error of law, a normal error of law. And this is still subject to the jurisprudence and the courts to speak about and to express their opinions about. Thank you.
Certainly. Thank you very much, Mohammed, for this presentation. And indeed, what forms a distortion of law, or what is considered a gross error on law varies also from a jurisdiction to another and from one applicable law to another. So, Ibrahim, would you like to comment on that?
Yeah, definitely. I think this is an issue that has gone through a lot of discussions over the years since the inauguration or the promulgation of the law in 1994. So at the beginning, there were very restrictive approaches towards this issue in specific, and it was always the courts of appeal were always talking about that you didn't apply it right, and there was this misconception that you can have a re-review of the merits. For me, I think how the UNCTAD model law is based, I think the only re-review of the merits that can be done by a court of appeal should be done through the public policy lens, and so that's the substantive public policy. So although I might not agree with some of the decisions, but I think even some of the recent decisions by courts of appeal, they are trying to base their decision differently. So, for example, Al-Kharafi case was talking about proportionality, and although it wasn't very straightforward application of public policy, but there was a mentioning of it, and that might be the lens that they reviewed the case through it, the public policy lens. So that whether I agree with whether I agree that proportionality is a public policy issue or not is different, but we're talking about how they review the merits and what would be the basis for that, what would be the ground for that. So the thing about manifest disregard of the law or distortion of the law is very ambiguous, and if we let it be a ground, I think it wouldn't be right. And I think the judgment by Mr. Nabil Omran in 2018, where it's because we have this very expensive ground at the end of the arbitration law, where it says if the award is null or the arbitral procedures are null, and he said that this should be a two-pronged test, that it should be that the procedures were really null and void, and that such procedures led to the nullification of the award, and it's not only one of them that should apply. They should be applied cumulatively, and that's why he disregarded, for example, the issue of the sitting judge having to have an authorization from the Ministry of Justice before being able to arbitrate a matter. So I think, as people said, as other distinguished speakers said in the previous panels, the Court of Cassation, especially, since 2017 or 2018, I think they have issued a list of decisions that have made it clear that we are trying to be an arbitration-friendly jurisdiction, and we are trying to apply the best practices in arbitration, and that doesn't go to distortion of law being a ground for annulment, unless it isn't a substantive public policy issue. So that's my take on it.
Thank you very much, Ibrahim. And moving on to the practical side, I would like to ask my co-panelists if you have any practical experience where in an arbitration, the application of several laws or any relevant situation that you recall from practice where the application of different laws has caused an interesting situation? Ibrahim? Or Muhammad or Muhammad?
So it's not it might not be like a practical experience, but it's based on like analysis of like over 120 awards, and I think
this is a practical experience.
So there was this very early award in I think 1990s by the ICC, where they were starting doing something called the cumulative approach. And I think if someone is interested in conflict of laws, they would find that the cumulative approach is a little bit driven from the interest analysis or the governmental analysis in the US, where they try to balance whether, like, we apply both laws. So they try to go to the reason why there's a conflict of law, which means that why are we having this discussion? So we first have to see whether both laws would lead to different outcomes or not, because the whole process wouldn't mean anything if both laws have the same provision at the end. So it would be a false conflict. So the cumulative approach, I think there was a case and they said, like, the position in Korea is the same as Morocco and the same as Yugoslavia, so we will apply the same law, it doesn't matter. And I think that was very interesting, and that was very innovative in terms of arbitration, because there was only people saying it's either voie direct or voie indirect. It's either you have full discretion and either you don't have discretion and you go to the conflict of law rules. So this is the first thing. The second thing that I saw that was very interesting is that in the EU, we have the Rome I regulation, which was preceded by the Rome Convention. And you find that there's my PhD thesis about law of police, which is, I think, something interesting for Dr. Ismail Salim and Dr. Muhammad Abdulwahab. I found that, even though the Rome I regulation says that it doesn't apply to arbitration agreements, and it doesn't say anything about like being applicable to arbitration, I think a lot of like the decisions that I saw, they don't find any analysis elsewhere, so they try to base their.
To the best of my knowledge, it's the Brussels regulation that does not apply to arbitration, but the
Rome doesn't apply to arbitration agreements, but but if you go to the arbitration laws, they always say most closely connected law. So there's no obligation to go to the conflict of law rules. So, but yet you find them trying to find something to anchor their decision in. So they find them eventually applying Article 9 about the loi de police in the Rome I regulation, which has very specific rules, and that's what makes me find it very interesting that it's usually if you don't find the answer, you try to find somewhere else to get the answer from. So the discretionary power with the voie indirect is not very broad as people might think, because you have to find the answer somewhere and you have to base it on something. And I think like Rome I regulation, given its stance as one of the most common convention, it's a unified convention for the whole of Europe. So people think that it has been like reviewed and it has been like analyzed a lot, and people arbitrators go to it either even not doing it purposefully, but they do it because they think that it's really good, and that's for me was an interesting take for my study.
Thank you for sharing this, Ibrahim. Muhammad, any practical experience on application of different laws?
Yes, my experience was about, it was such a very interesting case about applicable law on arbitration agreement. It was an ICC case as well, but it was connected to an investment claim based on a BIT, which included a provision similar to that of NAFTA 1119 regarding waiver. So therefore, the question was about whether the arbitration clause in the commercial side was waived or not. So the first question was about the applicable law on arbitration agreement. So the arbitration agreement itself stated, so the arbitration was seated in England, and the arbitration agreement stated that the applicable law on the arbitration is the Egyptian arbitration law number 27 of 1994. But however, so there was the English law and the Egyptian law in conflict on which law should apply on this case. However, around this time, the English Supreme Court or the UK Supreme Court issued its famous judgment. It was 2019, actually, I think, yes. The case called INSAT stated that if the parties actually agreed on a law governing the arbitration agreement, this law should apply, of course. If not, therefore, the laws applicable on the substantive issues of the case should apply. In this case, it was English law. In our case, and if not, then the tribunal should choose the law most closely connected to the arbitration agreement, not to the dispute, which should be the law of the seat. And in that case, the tribunal decided on it based on this judgment, which at that time had been issued, I think, a couple or more months ago or before. So the question was whether the arbitration agreement provided for expressly for an applicable law on arbitration agreement, which the tribunal found was not the case because it said that the law applicable on arbitration was Egyptian law. So at the end, stated that there was no law agreed by the parties on arbitration agreement, and found at the end that the law applicable on the arbitration agreement was English law because it was the law of the seat in case of the absence of an agreement, and also because it was the law applicable on the substantive issues of the case based on this ruling by the Supreme Court. So there were three laws of conflicting for being applied on the arbitration agreement, and fortunately there was an award or a judgment by the UK Supreme Court solving this issue only 2 or more months before that a tribunal issued its award. Sorry? The English Supreme Court. Yeah, so it differentiated between 3 cases. Yes, the first case is where there is an applicable law agreed by the parties on arbitration agreement. Therefore, in that case, there will be no issue. The second case is where there is no agreement on the applicable law on arbitration agreement, but there is a law applicable or the law agreed by the parties to be applied on the merits of dispute. In that case, the court ruled, the 5 agreed on by consensus, that this law applicable to the merits is the law that should govern the arbitration agreement itself, not the law of the seat. This is the second case. The third one is that the parties didn't agree on a law governing the arbitration agreement and didn't also agree on a law governing the merit of the dispute. In that case, and the court was divided in that case, it was 3-2. The majority stated that the tribunal should choose the law most closely connected to the dispute, not to the dispute in the merit, but to the dispute about the arbitration agreement itself. Which
about Inca versus Chad.
Yes.
2020.
2020, yes, 2020, actually, yes.
You mentioned 2019, and that's the INSEAD, it's a separate one.
No, I got INSEAD. No, the INSEAD one.
Yeah.
The INSEAD one.
The Inca is the proper test under English law.
Okay.
2020.
Okay.
Inca versus Chad, and that's where the division.
Yes.
Where Lord Sales had deviated, and it was about the Russian.
Yes, exactly. Yes. But this was the one that yes, and this was the one that the tribunal relied on when issuing its award. So they stated that if the law applicable on the merits was not agreed by the parties, so the tribunal should apply the law most closely connected to the arbitration agreements, which is the law of the seat, or which is in most cases the law of the seat, not the law applicable on the merits. While the minority stated that the tribunal should choose the law most closely connected to the dispute in general, which is the law, whatever law the tribunal finds applicable on the merits.
Thank you very much, Mohammed. That was an interesting experience. I would like also to share that the application of different laws or this dilemma is not always caused by foreign laws or laws of different nationalities. a couple of years ago, we had a case under a governing law of one of the GCC countries, and the arbitration law of that country was issued recently, and it said that it applied to every arbitration where the seat is that country. The problem was that the law governed there was an ongoing arbitration, and it was an ICC case, and the law applicable to the arbitration agreement could not be the arbitration law that was enacted during the proceedings. So basically, there was a carve out where the law applicable to the arbitration agreement was the former chapter that regulated arbitration under the Code of Civil Proceedings of that country, and that was quite dramatic because the parties were shocked when we highlighted that. But eventually, going forward, whether it was going to be problematic and very complex procedurally, so the parties and the tribunal were all inclined to proceed with the application of the arbitration law to the arbitration agreement as enacted. So the point is that this dilemma of applicable laws does not necessarily arise between laws of different countries. You can have different schemes of laws applicable within the law of the same country. I would like to move to Ola if you have, and I'm sure that the state had. I know you joined recently, but have you had any experiences with different laws applying to the tribunal to an arbitration where the state is involved?
Well, not yet. So I promise you next time we share a panel, I'll answer to this question.
Okay, there are, okay, for just so you know, there are many that where the state is involved in arbitrations.
But I haven't experienced them myself yet.
Okay.
Myself yet.
Okay, and given the international nature of different laws applying to an arbitration, would you Ibrahim have any international aspect to address on how this issue is approached across different jurisdictions, the application of different laws? Examples
of different jurisdictions?
Yeah, other than Egypt, for example.
To be honest, it's I cannot recall a lot of examples, but I would say that that most jurisdictions follow one of two approaches. It's either voie direct or voie indirect. So it's either that you go to the most closely connected law without being obliged to go through the conflict of law rules, or either that you have to do it in a two-step process. You go to the conflict of law rules and then you go find the law that is most closely connected based on that. But I think, like, for example, I think I remember that, you know, some institutions have different approaches. Like, for example, I remember the Hong Kong institution have you know, changed its rules where you can agree on the law applicable to the arbitration agreement explicitly under the arbitration agreement, which they found that would be more useful to avoid conflicts on that area and go through with it. But I think, like, the finding the law to be honest, like, before doing research, I thought like this issue wouldn't come up a lot where the choice of law is absent, but actually it comes up a lot. And especially in contracts like sale of goods, where, like, you know, the dispute resolution, where the whole contract is one page, and you find, like, you know, the words like arbitration, London, and that's it, and you don't find anything about the law applicable to the merits. So and even arbitration in London is debatable whether it's a valid arbitration agreement or not in some jurisdictions. For example, in Egypt, it was held to be invalid in 2007, and that's another issue. But, you know, they thought that it was ambiguous. So the thing is that there are different, like, you know, approaches, and I think the ICC arbitral awards where I did some research, I think there were very different approaches. For example, especially with respect to the effect of mandatory rules, the effect of overriding mandatory rules, and whether the interpretation of the choice of law clause itself is very different across arbitral tribunals. So the thing about arbitration is that the conflict of law rules and arbitration laws are very, very seconded. They're not extrapolated or anything. So that gives a lot of discretion to the arbitral tribunal, which at the end of the day, you find different approaches to that.
Thank you very much. Would Mohammed or Ola, would you like to comment?
No. I just want to clarify something,
sure.
Which Dr. Mohammed drew my attention to actually. So I mentioned in the beginning that the applicable law or this provision on exclusion of applicable law is only mentioned in Egyptian law. I just meant that it's not in the UNCITRAL model law or in New York Convention, but it's found actually in other laws which were apparently imported from Egyptian law because they seem to be laws of the Gulf states. Sorry?
US manifest disregard. Omani, Jordanian, Syrian, Qatari law, they have the very same provision. Some of them very same.
But it's not most probably they were imported from Egyptian law, right?
They are.
If they're imported,
yes,
definitely.
It's only.
Yes, exactly. Yes. Thank you. Thank you.
There's a question from Mohammed.
No, I just have a small question. I mean, shouldn't the gross error in application of the law should have like a very high threshold? Like, I mean, the arbitrators in the first place doesn't have to be lawyers, simply the counsel of lawyers. So shouldn't the threshold should be like very high to define when there is a gross application of law? I mean, this concept of the gross application of law is like, I see it like a regulation or a legalization of the interference of the judges in the arbitral process as a whole. I don't mean by the gross error like the public policy rules or data rules. I mean just the gross. Who defines it? Like, is there a reasonable man's test or a lawyer's man test? I don't know.
Okay, the question is addressed to Mohammed, yeah? You work together. Okay. So okay, Mohammed.
So
it's not to Mohammed, or
it is for the whole panel.
for the entire panel. Okay. So okay, Mohammed, would you like to address it or?
Sure. So my answer is that whatever narrow we can make it, whatever narrow we can make it, it will still be subject to ambiguity and to different opinions, and it will still be a backdoor where an actual review for merits can be or can enter into this exclusion thing, because there were so many other examples of these vague terms that we say they should be kept to the lowest limit. They should be kept to the lowest limit. So, for example, under English law, there is the concept of legitimate interest, and it was in AG versus Blake. I think it said one of the lords rendering the judgment said this would be in the lowest extent possible, and it was regarding national security and examples like this. And then after that, in other cases which did not involve similar stakes, it was applied, and it's still until now not agreed on what is the definition of a legitimate interest, although it's applied in many different contexts. So my answer actually would be whatever narrow this, of course, it should be kept to the narrowest extent possible, but whatever narrow this is, this will still be subject to ambiguity, different opinions, backdoors for reviewing merits. So it is either to remove completely or to live with, of course, to the lowest extent possible, but live with the ambiguity and the different opinions.
Okay, Ola, Ibrahim, the question was for the entire panel. Would you like to comment or? أنا علشان والله مؤمن قال إنه it's for the panel كلها. يعني أنا شخصيا I will comment. بيلمعوا أنا شخصيا I will comment فقلت أسألهم الأول. The only thing I want to add to what Mohammed said is that if you'd like to find the threshold or the test, you need to examine first the legislative philosophy in addressing arbitration in a particular jurisdiction, and whether it observes a quasi-judicial role for an arbitrator as opposed to the local judge. I think this is the starting point, because this what tells you how far an arbitrator can go and what is the threshold to monitor, if we may use that term, to monitor an arbitrator's performance, because this is what is really being tested on this aspect. When you approach gross error in law, it really depends on the lens from which the legislator looks at arbitration and arbitrators in general.
So I believe that's like the threshold is very low here.
Yeah.
I believe that arbitration is like a judicial.
I would pick here from what Professor Abdul Wahab said in the previous panel. It's that we are born in an environment where arbitration is viewed as an exception, and this is in addition to what was explained on that. I personally believe that this is simply historically wrong, because arbitration has indeed existed ages before state courts have. So the notion itself is simply incorrect, that arbitration is an exception. So given that it is still being regarded as an exception, and the decision of the Court of Appeal was I think reversed by the Court of Cassation, that was the only decision that we had from Egyptian courts saying that arbitration is not an exception. It's just a different arena for resolving disputes, but the Court of Cassation has reversed that. But until this view changes, you are right that the threshold, given that you are already acting in an exceptional arena, the threshold, what I have seen so far, that it takes a lot for an Egyptian court to rule that there has been a gross error in application of the law. It's really a high threshold, I would say so. It's not easy to get a decision to that effect from an Egyptian court. So that's, I believe, the case so far in Egypt, if you're asking about the threshold. I think Momin has started the Q&A session earlier than I planned. Part of being a moderator is to keep an eye on the time always. I owe this to the organizers. So I will go with the Q&A session since Momin has started it. So the floor is for the audience. Mohammed.
Thank you. I just have one question. Thank you.
طب انتوا بتشتغلوا مع بعض صح؟ طب ما كنت تسألوا في المكتب. What's your question? Huh?
Make one comment in relation to the hypothetical scenario you gave, where the parties have agreed to the application of the commercial law, but the tribunal decided to apply the federal law. I understand that your position is that the tribunal in such case has excluded the applicable law.
It's not my position. It's just that it was actually subject to different opinions. It was subject to different opinions in the jurisprudence, but the Egyptian Court of Cassation, when ruled about this, stated that if the parties, for example, agreed on the application of Egyptian law in general, so the application of a different or of a wrong branch is just an error of law, not an exclusion of the applicable law. But if the parties agreed on the application of the specific branch, so of the parties, for example, stated the law applicable on the dispute is the Egyptian civil code, then in this case, there would be an exclusion of law, of applicable law, if the tribunal applies, for example, the administrative law or whatever. So this is the difference between the two cases. However, there is a case that seems to be in the middle, which is if the parties agreed on Egyptian law. And however, they say that this contract, for example, is a construction agreement or is a works agreement or is whatever. So they classified it into a certain classification, and the court or the tribunal deviates from this classification or characterization and applies the law of another contract. So, for example, apply the rules governing sales contract, for example, under the civil law. So in this case, it seems to be a deviation from what the parties agreed. However, since the position of the courts is that the issue of characterization is subject to the tribunal without being bound by what the parties named the contract, therefore, the court stated that this is not an exclusion of the applicable law. So,
my question was the scenario 8 was the commercial law, the law that was chosen by the parties was the commercial law, while the civil law was the one of plan.
yes.
Okay.
So
in that scenario, when I recall that you mentioned that in such case, the tribunal has excluded the applicable law chosen by the court.
No, I said the tribunal should be excluding if the party stated that the applicable law is the Egyptian commercial law or the Egyptian civil law, if the parties expressly stated so. But if they stated Egyptian law in general, so in this case, there would be an exclusion, right? Because the tribunal would have been deviated from the law agreed by the parties.
I have a question. Commercial law said
How?
say that the commercial law has a provision that says that
Yes.
No, I have an answer. So in this case, there would be an exclusion if the court applies civil law in the wrong order. So if the court, for example, the tribunal, for example, applies civil law to the presiding or firstly, before visiting the parties agreement itself, which is number 1 under the commercial law, for example.
Wouldn't that be reviewing the case of merits?
For me, it would depend. For me, it would depend on what the tribunal finds. So, for example, if the tribunal stated that there was no agreement by the parties or no provision under commercial law, therefore I apply civil law, this will be, as you say, even if it's wrong, this would be a review of the merits. This is one thing. It's another thing for the tribunal to say there is an agreement by the parties and there is a commercial law rule governing the dispute. However, I will apply the civil law. In this case, in my opinion, of course, it was not subject to, or as far as I know, it was not subject to any jurisprudence. But in my opinion, this would be this should be considered as an exclusion of the applicable law.
If the party said that the governing law is the Egyptian Code of Commerce exclusive. No, I was not raising a question. You asked for one question. Huh? Those were 3? Oh, 3. Okay. Okay. Any further questions? Sorry, the question is for? Okay.
Part of the case to interpret the arbitration agreement because the law that by the parties on the arbitration agreement does not include rules or provisions for the
Okay, thank you. It's a good question. Let me just make sure I understand your question correctly, because you mentioned that the parties agreed on a law that is applicable to the arbitration agreement, correct? Yes, and then you said that the tribunal finds that the arbitration agreement is ambiguous.
Yes, but he said something. He said the law governing the arbitration agreement does not include rules on interpretation.
Yes.
And that's purely theoretical. And I'm yet to encounter a law that does not include. But assuming that is the situation.
Okay, so the tribunal finds that the arbitration agreement is ambiguous on not on the part that there is an agreed law to apply to the arbitration agreement. Do I understand you correctly?
Yes, correct.
Okay, so your question is, can the tribunal go to the substantive law to interpret the arbitration agreement? Okay, now if the law applicable to the arbitration agreement is expressly agreed and is already there in the arbitration agreement, and as Professor Abdulwahab said, we have not encountered yet a law that does not include rules of interpretation, then I think the tribunal should look into the arbitration agreement within the boundaries of that law that the parties agreed to. More or less, this law will provide some way to address this arbitration agreement, but going to a different law, which is the law applicable to the merits, to interpret the arbitration agreement would probably be the best approach by the tribunal. Unless
no, it's fine. It's an interesting question, not raised before. It's purely theoretical. To answer you theoretically, briefly, if I may.
Sure.
You go back to the position, which is basically, if there was no choice by the parties governing the law of the arbitration agreement, what law will apply? Is it the seat or the substantive law? And then based on the applicable norm in the jurisdiction, you would import the rules of interpretation based on that rule, on the assumption that there are no rules of interpretation under the law governing the arbitration agreement. That would be just my own view.
Thank you, Professor. But I have a question, if I may. But this wouldn't be the case where the starting point is that there is already a law agreed to apply to the arbitration agreement.
It is agreed.
Oh,
It
okay.
doesn't include the provision.
Okay.
But there is a caveat.
Okay.
What would you do? You will treat it as if there is an absence of choice.
Okay.
On this for only purpose to find a practical way out. Because otherwise, there will be no way for them to reason what rules of interpretation they will rely on.
But not to dig more into that law agreed.
You definitely dig more, but ultimately he said you will not find.
Okay.
That's the premise. That's the factual matrix is presenting us with.
Thank you very much, Professor. Any further questions to the panel? Okay, I know you all had a long day, so sorry for keeping you that late, but I think we managed to adhere to the allocated time slot, more or less. Have we exceeded?
More or less.
Okay, because I thought we started at 7 or so. Anyway, we're happy to be with you, and thank you very much for my esteemed co-panelists, and for the audience, and for the organizers, and for everyone that exerted effort to put all this together and to make this event happen.
Thank you very much to our panelists for an enlightening and informative discussion. Our next speaker is Associate Professor Yahya Badr from the University of Alexandria, who will be giving a short speech on the CISG, I believe, before closing remarks.
Good evening. I hope that sound is clear, because we had a couple of technical problems from my side. So please confirm if you can hear me clearly and if I can see me clearly. That will be
We can both see and hear you.
very well. So without further ado, my topic will be very simple. We're talking about CISG as the applicable law for international contracts of sale. Now, please bear with me. topic will be about the shortcomings that affects the application or the utility of the CSG as a body of law governing international contracts of sale.
Professor
Yes,
Beth?
we're just facing some technicalities. Hopefully it will. I apologize. At the last minute where we were just making the tests, something went wrong from my end, and now things will get much better. Right? Yes. Could you please confirm if you're seeing the PowerPoint clearly on the screen?
Yes, the PowerPoint is on the screen and we can hear you.
Very well. We'll begin. Now, the topic of what I'm going to talk about is the CISG's shortcomings as the applicable law. And I'll be focusing on some of the causes and the remedies that we can use to overcome the shortcomings. And basically, you're going to find a lot of points that our colleagues in previous panels had discussed. So I will try to focus on what really matters today. Now, with international contracts of sale, we have two main questions. The first question has to do with the law applicable to the contract of sale. The second question is the forum set to hear the disputes if a contract of sale was not executed as perceived by the parties. Now, the CSG was meant to address the first question. And as Professor Amel said in her excellent presentation earlier on today, this effort was a culmination of several years of attempts, which aimed to do two main objectives. First of all, trying to avoid choice of law rules as much as possible by creating a set of uniform rules applicable on all of the contracts of international sale. And the second aim is to achieve certainty and predictability. Because when we have a uniform set of rules that we know beforehand will be applicable to our contract of sale, we do not have to design and focus or devote time and resources in trying to address contract by contract basis, the legal framework for each contract. We have a treaty, and hopefully this treaty should govern all the issues. However, CSG has its own shortcomings. And the first shortcomings has to do with the rules that are governing the scope of application. And precisely, I'm talking about Article 1. Article 1 puts two different case scenarios for applying the CSG. The first case scenario is when both parties are in two different states and both states are contracting states. And this is very important to emphasize that both the seller and buyer must be located in two jurisdictions, two different states, and each state should be party to the CSG. So it's not enough that we have two parties who are living in two different states. Those two states must be also parties to the CSG. The second phase, or the second instance where CSG can be applied, is when the two parties are in two different states and the rules of private international law in the forum indicates the application of a contracting state, meaning that if A and B both located in two different countries, and for some reason the dispute was being heard by country B or country A or country C, if choice of law rules indicates a country that is a party to the CSG will be applied. Now, this is really a shortcoming in the way that the CSG was drafted, because in the area of e-commerce, place of business is no longer a relevant connecting factor. You see, Article 1 is what we call a unilateral choice of law rule, a choice of law rule that determines when exactly will the CSG be applied. And because of the fact that its application is tied to place of business, in today's world, place of business is no more relevant. Nobody cares when he goes online where's the seller is located, and the buyer does not care where the seller is located. What they're interested in is concluding a contract in which one party will give away his money in order to get a product or a merchandise or commodities from the other party. Second thing is, the CSG excludes a huge scope of contracts from its scope of application. Contracts which are concluded by a seller or buyer who happens to be residing in the same state. Just because the seller and the buyer are residing in the same state does not mean that the contract of sale does not raises the questions of choice of law. On contrary, it could be a possible that both parties in the same state, located in the same state, yet the contract touches and raises questions of choice of law. And this happens when we talk about intercorporate dealings and contracts where two corporations who happen to be specialized, like a corporation specialized in manufacturing cars and another specialized in manufacturing engines, and they agree on a contract of sale where the goods themselves, the engines, for instance, is being sourced from outside their common domicile. So it's an international contract. But because the CSG, the way it was drafted, this international contract will not be governed by CSG just because the parties share the same domicile and same place of business, which does not make sense. The third also shortcoming is that if we look at the articles of CSG, we find that in Section 2 of Article 1, it allows the parties to avail themselves to claim that they did not know that the contract was governed by the CSG if they prove that the dealings or the contract or the negotiations between them did not indicate that they do not share the same domicile, which is quite peculiar, to be frank. I mean, most international conventions in international trade, they do not allow parties to avail themselves to evade the convention just because they were not aware of the other party's domicile. And to be honest, I do not understand the logic behind this clause. I mean, if it's an international, if both parties are in the business of selling goods, most likely they are in businessmen. We are talking about B2B contracts where we cannot find any evidence that tells that people are being fooled where the other person is located. Now, also another problem with CSG is that it does not define what is a contract of sale. You don't find any definition of contract of sale. It doesn't define goods either. And this is something that's really interesting because if we look at the 6 versions of the CSG, the 6 official languages, we'll find that the word goods is quite different in each language than the other. I mean, in Arabic, when we're talking about bada'a, and these are tangible goods. In other languages, like in English, word goods can be used to include other intangible assets. And in fact, some courts in the common law jurisdictions have interpreted the word goods to include some intangible assets. Lastly, that something is very interesting about the CSG. Article 6 of CSG allows the parties to opt out of CSG, meaning that they can put a clause in their contract and say that they not wish the CSG to be applied to their contract, but not the other way around. Like for instance, if you look at the Hamburg Convention for carriage of goods by sea, the Hamburg Convention for carriage of goods by sea, which was signed in the same year, 1980, allows the parties to opt inside the Hamburg Convention. Even though the Hamburg Convention was not applicable by force of law, they can choose it by contract. In CSG, we don't find this logic. We find that people can opt out of CSG, but they cannot choose CSG unless it was applicable, which is a shortcoming, I believe, that affects and limits its utility. Another problem with the CSG is the gaps. Gaps meaning issues that the CSG does not address. Now we have external gaps and internal gaps. External gaps are issues which was clearly the CSG said it will not address, which is the validity of the contract, the effect that the contract have on the property. And when we say effect that the contract have on the property, we're talking about the transfer of ownership, which to me is astounding because that's the main reason people making a contract of sale of goods. They seeking transfer of ownership of the goods in order to circulate it, in order to use it. So the fact is that the convention decided not to address this issue is, to me, is very astounding, and it's a major weakness, which explains why, unfortunately, there has been a quite significant amount of contracts of sale where people just opt out of the sale of goods, opt out of the CSG because of this issue. The issue of that ownership is not being dealt with within the CSG. Now, the problem also with external gaps is will be left to determined by the forum's choice of law rule. And these choice of law rules are very variable and differs. I mean, let's take, for instance, the Egyptian code, civil code. The Egyptian civil code has one simple choice of law rule, which looks to the party's selection of law. And if they do not select the law, it looks to the party's common domicile. And if they do not find a common domicile, then the place where the contract was concluded. And it's just one choice of law rule for all types of contracts. On the other hand, if you look to Rome regulation, Rome 1 regulation has a specific rule for contract of sale. Unless the parties choose a law to govern their contract, the Rome regulation will direct the court within the IU to apply the place where the seller's business is located because he owes the most characteristic performance. Therefore, if we're talking about a contract concluded between an Egyptian exporter and a European importer, and we had a dispute where we have to fill the external gaps, the way the external gap will be filled by Egyptian choice of law rules will be vastly different than that filled by the Rome 1 Convention. And I believe this goes against the real issue or the real purpose of the CISG. In addition, we have something called the internal gaps, which are issues that supposedly the CISG should regulate, but did not have a specific and special rule to address, such as the rate of interest, which is the rate of interest given as a part of the compensation for not performing or failure to perform the contract of sale. We also have issues with foreign currency issues, like for instance, how should we calculate the exchange rate if the contract of sale is dominated in a foreign currency? We have several rules in different jurisdictions. Some jurisdictions follow the judgment day rule, others follow the payment day rule. Other countries do the breach day rule. So we do not have a single rule that will allow us to address the issue, what should we do when the contract of sale is dominated in a foreign currency? Now, the CSG says, well, go ahead and apply general principles. Well, unfortunately, general principles do not give us specific solutions. I mean, when it comes to interest rates of interest, the Egyptian law has a distinction between interest rates for commercial issues, commercial contracts, and civil contracts. Other jurisdictions do not have that distinction. the Egyptian law has a maximum tab on the amount of interest to be paid, which is 7%. Other jurisdictions do not have such a tab on cap on the amount of interest awarded. So this is a shortcoming. Now, in order to remedy or to find a solution for these shortcomings, we have 4 different choices. The first choice is opt out the CSG completely and choose a domestic law, for instance, English law, or to choose the unit de droit principles for international commercial contracts, or choose a model contract which is suitable for the transaction, or a hybrid choice of law clause coupled with an arbitration clause. Now, choosing a domestic law will lead us to 2 things. First, we have to rely on the forum's choice of law rule. Now, not all choice of law rules in different jurisdictions have the same scope or the same, allow the same the parties the magnitude or latitude to select the law governing their contracts. Some jurisdictions pose some restrictions, others don't. And for those who are interested in understanding how various jurisdictions deal with party autonomy, recently I had the honor to participate in a chapter in the book addressing this issue. It was published by Oxford University Press. And if you'll be amazed to see how different jurisdictions deal with party autonomy differently. The second issue, which the panelists, the last panel touched upon, was the issue of proving foreign law. Now, under the Egyptian, for instance, the Egyptian system, foreign law is not treated as law, strictly as law. It's treated more like a fact. And it has to be presented in a translation into Arabic. So this represents a problem when choosing a foreign law and putting the issue before the domestic court. There will be issues of proving the foreign law and translating that foreign law from its original language to the forum's official language. With choosing the unit droit principles of international commercial contracts, we fall under different set of problems. First of all, the unit droit principles are what we call non-state rules. Non-state rules mean they're not promulgated by a legislative body belonging to a certain jurisdiction, or while not developed by case law of a certain jurisdiction. It's simply being developed by people of business who aim at trying to achieve certain certainty or try to regulate a certain transaction. And not all jurisdictions are receptive of non-state rules. Some jurisdictions do not allow non-state rules. Others regulate non-state rules to be complementary rules, such as the position in Rome 1 regulation, where non-state rules are being allowed to the extent where the what we call the auxiliary state law allows. It has an auxiliary role, does not have the primary role. And also we have the language barrier, because the unit droit rules, even though there was an Arabic translation of the 2010 rules, but 2016 rules, I did not find any translation for that set of rules. So it'd be a burden for the parties to translate over 500 pages of rules from English to the forum's language, especially for us, we're talking about an Arabic speaking country like Egypt. Now, the third choice, which is the best bet, is used by the ICC Model International Sale of Contract for Manufacturing Goods, which is a hybrid. A hybrid choice of law clause coupled with arbitration. Now, in this case, Article 110 of the ICC Model International Sale Contract for Manufactured Goods states that questions related to this contract, which are not settled by the provisions contained in the contract itself, shall be governed by the United Nations Convention on Contracts for International Sale of Goods, and to the extent such questions are not covered by the CSG and that no applicable has agreed upon by reference to the law of the country where the seller has its place of business. Now, this choice of law rule, hybrid choice of law rule, tries to bridge the internal gaps and external gaps. How? By saying that we have a contract, they put in the contract as the first layer of regulation of the international sale of goods. Failure of that, CSG will be applied. But because CSG has its own external gaps, as we said, here the parties fall back on a third layer of regulation, which is the domestic law of a jurisdiction. Now, it's important to understand that these hybrid choice of law clauses cannot be effective unless it was coupled by arbitration. And the reason is that because, first of all, by inserting an arbitration.
Dr. Badr?
Yes.
I'm sorry to interrupt you. If you could just, we're trying to really keep to our schedule.
Oh, yes,
So,
I will be finishing. We're finishing right now. Just 2 minutes.
Okay. Thank
you.
you.
It was the choice of law question. It allows us to use arbitrators with specialized knowledge. Proof of foreign law is much easier because you're bringing arbitrators who have the exact knowledge of the law. There's no issue with non-state rules. You don't have to deal with choice of law issues because most of the jurisdiction or most of the arbitration codes use what we call the devoir direct, which allows the panel to apply the law directly without any choice of law rules. And thank you very much for your attention. Thank you. I'm done.
Thank you to Dr. Yahya Badr for a very different presentation. We will now be moving on to our closing remarks in about 5 minutes' time. All right. Thank you, ladies and gentlemen, for being so patient, and I hope you enjoyed today. For our closing remarks, please welcome Dr. Muhammad Abdelail from Alexandria University, who
All right, good evening. What a day, right? We had a really interesting day, a fruitful day. I know it's also a long day for everyone. I'm sure everyone looks tired now, but I want to thank all of you again, the eminent speakers and professors and academics, the honorable practitioners as well for participating with us this year. And we hope to see you next year again. Right, so this is a promise that every one of you, please, Professor Muhammad, will see you again next year and hopefully at Alexandria. So, inshallah. Thank you again, and I'll leave the talk for Dr. Ismail. Thank you.
Thank you, Dr. Muhammad. Ladies and gentlemen, it was a pleasure hosting you today. So now comes the end of this pre-moot, the second Alex University-CRCICA pre-moot, and the end of the conference. I'm very glad because we had a successful pre-moot and a successful conference. I'm certain you are all tired as much as myself. I'm sure also you were glad to come to our conference facilities for the first time, I believe since a very, very long time. And I thank you for your kind attendance and wish you all the best, and wish to all the participants, the pre-moot teams, a successful participation at the VSMOOT itself. Thank you, and see you next year. See you all next year, inshallah. And we will all survive, inshallah.